Okay, I'll call the July 12th meeting of the Falmouth Zoning Board of Appeals to order. The first part of this meeting is an open meeting where we're going to reorganize the board. And I guess I would like to begin by nominating T.J. Hurry to be the next chair.
I will second that motion, or nomination.
All right, there's no discussion. No one,
Or any other nominations?
or any other nominations? Thank you very much. All in favor?
Aye.
Aye.
Okay.
Do we have a changing of the gavel?
I don't think
Stand
that-
up, pledge
I don't think that
allegiance.
happens afterwards.
Until the very end of the, okay, so next we need to nominate a vice chair.
I will nominate Ken Foreman as vice chair.
I'll second.
Okay. Any other nominations? Hearing no other nominations, all in favor?
Aye.
Okay. And next, we need to nominate the clerk of the board.
I will nominate Kim Beelen as clerk of the board.
Okay, is there a second?
Second.
Any other nominations? Hearing no other nominations, all in favor?
Aye.
Okay. Excellent.
Thank you.
Okay, so now with that, can I hand over the gavel?
You hand over the gavel, sir,
Actually, I'll just hand over the chair, and then we can.
Oh, you want
That's
and the
easy.
nameplates.
And the name.
And we have a few minutes if somebody would like to make a motion to take the agenda out of order to do our open meeting and review minutes.
I would make a motion that we take the Climate House continuation, 086-17.
No, that's set for 6:30, Ken.
Oh, can't do
Yeah,
the
this is the
can't do
open
it.
meeting.
climate, oh, can't do the climate fund.
So just
Okay,
do minutes, please.
all right, okay, minutes then.
Is there a motion to take it out of order?
I'll make that motion.
I'll second the motion.
Motion made by Ken, second by Kim. All those in favor?
Aye.
Okay, minutes, June 7th and June 21st of 2018.
Oh,
So everyone had a chance to review the minutes?
Was that Patterson? I think so.
You think so?
Take,
Oh, is it Patterson? I'm just trying to remember the name.
that was one of the applications.
Yes, then I was here.
yes,
June
yep,
7th?
yep.
All right.
I read it.
Oh, wait. That's the, Patterson was the 21st. Oh, and the 22nd.
I think I read both.
And the 7th, sorry.
Yeah,
There were patterns in
the
them
dates in the paragraph.
And would anyone like to make a motion to approve the June 7th minutes as drafted?
So moved, as drafted.
Second.
All right. All those in favor?
Aye.
Aye.
And I'll abstain, I wasn't.
Next, we have the minutes of June 21st. Has everyone had a chance to review them?
Yes.
Yes.
Any comments, changes? Entertain a motion to approve the minutes of June 21st.
Make a motion to approve?
Motion was made by Ed. Is there a second?
Second.
Okay, second by Jerry. All those in favor?
Aye.
Aye.
And I will abstain.
Okay.
Okay, you'll have to take a 5-minute break because the administrative approval, I believe the people will be here, so there's no sense in doing that right now.
Okay. We'll be on break for 5 minutes.
Thank you.
Good evening and welcome to the July 12th, 2018 hearing for the Zoning Board of Appeals. We'll begin by asking you all to please silence your cell phones, and I'll introduce the board at this time. To my far right is Jerry Patamas. He is an associate member of the board. To my immediate right is Ken Foreman, vice chairman of the board. My name is Terrence Hurry. I'm the chair of the board. To my left is Kim Beelan. She is the clerk of the board. To her left is Ed Van Kuren. He is a member, followed by Paul Murphy, who is another member of the board, and Bob Dugan, who is an associate member. We also have Sari Boudreau and Ashley DeMello, who is our recording secretary tonight. The Zoning Board of Appeals is charged with applying the zoning bylaws for the town and considering requests for special permits, variances, and appeals as provided in the town's bylaws, which have been approved through town meeting and the Attorney General's office for the Commonwealth of Massachusetts. All of our decisions are made through the public hearing process. Our goal is to hear testimony from the applicants and the public and allow full and fair discussion of the project prior to rendering a decision. To begin each hearing, the clerk will read the public announcement of the hearing and then present any pertinent information from the file, such as referrals from town departments and summarizing correspondences to the board. The applicant or the applicant's representative will then have 15 minutes to make a presentation, and if we deem it necessary, time may be extended by a majority vote of the board. Then the board will question the applicant, and then we will invite the public to make any comments or questions. Public comments should be directed only at the project, and I ask that you please refrain from making any personal or derogatory statements. These statements can include an opinion in favor or in opposition, or it just might simply be a question regarding the nature of the project. We can limit discussion in the interest of time if comments do become repetitive. All members of the public wishing to speak should wait to be recognized by the chair, and they should come to the podium to the right here, and please state your name and address for the record. We will then either close or continue the hearing when the board is satisfied that enough information has been presented by testimony and in the file to make a decision. By motion and vote of the board, the hearing will be closed. Alternatively, we may continue the hearing to a future date and time certain if we do need more information. After a hearing is closed, no more testimony may be taken. Regarding board discussion and decision, the board may then further discuss the project among ourselves and make a motion to deny or approve the project will be made and voted upon. The motion will include a summary of key findings and conditions. An affirmative vote of 4 members is required for approval of motions on special permits, variances, and appeals. Split votes such as 3-2 would be a failure to carry and results in a denial. Under Massachusetts general law, if a special permit is denied, the applicant cannot return to the board for 2 years unless the project is substantially different. And turning to our agenda for the night, we do have 4 hearings, 2 continuations, and some open meeting agenda items.
Okay, Mr. Chairman, could I make a request that we take Climate Foundation out of order?
You may. So the motion is made by Ken. Is there a second?
Second.
Second by Ed. All those in favor?
Aye.
Aye.
And I'm not sitting on this.
Okay. We'll see you soon. Attorney Wall, whenever you're ready.
Thank you, Mr. Chairman. Through the chair, for the record, my name is Brian Wall. I'm an attorney with an office in Sandwich, and I represent the Climate Foundation, and together with me tonight is the executive director, Dr. Von Herzen, and his assistant, Rebecca Truman. I know that this is the 3rd night of remand hearings, so I'm not going to go through the facts or even what the case is about, because I think the board is very familiar with that. I think what we're down to now, and I'm not presupposing the board's vote and decision, but as far as the discussion is concerned, we're focused on some conditions, and I do have a brief statement that I'd like to make to explain how we got to where we are and where I think we need to go to try to wrap this up tonight. You might recall that this appeal is of a decision that was issued back in 2016 by the board, where the board granted an abutters appeal to overturn a decision by the zoning enforcement officer that found that there were no violations at the property because the property was being used for educational purposes. In reaching its decision to overturn that, the board focused on several matters, including a finding that Climate Foundation was indeed engaged in educational activities and was a qualified nonprofit organization. But the focus of the decision was on the holding under Regis College, which requires that in order for an educational use to be qualified as exempt, the property has to be primarily and dominantly used for educational purposes. And the board found, based upon the evidence that was presented, that the primary use of the property was as a lodging house. Although activities were occurring as far as educational uses were concerned, the board was not persuaded that the quantum of use was over that threshold. So Climate exercised its right of appeal and filed an appeal in the land court, and then by agreement of the parties, we asked for this remand. And as you know, we engaged in a mediation session. The case that the foundation has been making to the board is essentially that the evidence that the board heard at the 2015 and 2016 hearings was outdated. It was based upon activities at the Climate House in 2013 and 2014, and we made the argument that the educational use had grown because the 2 years that the abutters focused on were basically startup years, and the business of Climate House was getting going. We also made representations that the Airbnb website that was used in the infancy of the program was no longer used and would no longer be used, and any persons that were staying at the house had to be part of the programs involved as far as Climate House is concerned. Also during the mediation, we highlighted some of the educational activities that were going on, including the fellowship internship program that had grown, the daily class on permaculture that was being given, and the fact, again, that 100% of the people involved staying at the property were involved in the programs. And at the end of the mediation, what we did was to provide the board some assurance to feel comfortable that the educational use was there. We had come to the mediation with a set of 9 conditions, and the 9 conditions were essentially putting in writing the representations that Climate House was making to the board, and it included those things that I just referenced about the internship program and about who could stay at the house. And without putting words in the representatives that attended the meeting, it appeared that the conditions were favorably received, but that the board wanted a little bit more detail and asked us to prepare a revised set. And we did. We submitted a set of revised conditions. It went from 9 up to 11, and we submitted that with our materials for the remand hearing back in September of 2017. Then the board held its first remand hearing, and much of the discussion was focused upon the things that I just talked about, and the conditions kind of came up at the very end of the hearing. And when the conditions came up, it was already clear that there was going to be another continuance because the board wanted a safety inspection done for fire and for engineering purposes. So the conditions really weren't discussed. The hearing was continued, and there was another hearing in May. And just prior to the May hearing, I exchanged emails with Associate Town Council Pat Harris, and we tried to come up with some more revisions to the conditions. And I think at this particular point, I realized that we might have started down what we lawyers call a slippery slope. Because what happened was, I think the town, in its good faith, was trying to impose and get into the conditions things that it wanted to see with regard to the educational activities at the property. But from my client's perspective, it started to cross the line and get into essentially micromanaging the activities. And we ended up having a disagreement at the May 3rd hearing where my client agreed to much of what had been added to the conditions, but not everything. And so the hearing ended with an understanding that a memorandum would be prepared comparing the conditions so that the board could take a look at where we were in the process. And Attorney Harris did submit that memorandum the day before yesterday, and I was able to talk to my client about it today. And the list of conditions has grown to 16. And we reviewed all of the changes, and we can agree, we are in agreement on 8 out of the 16, and we are going to agree to 2 of the changes that the town wants. So we now are going to be in agreement on 10 out of the 16 conditions. And we are prepared to discuss them today, and/or prepared to submit it to the board for the board's decision. But I'd like to make 3 simple points with regard to how the analysis should go forward with regard to this. First of all, this is the 3rd remand hearing, and my client, who is a nonprofit in the business of education and research, really wants to resolve this matter tonight and is willing to cooperate with the board and has cooperated with the board. And as I said, is it willing to agree to some additional changes to get to the point of agreement on 10 out of the 16 conditions. But secondly, I'd like to remind the board to take a step back and look at where we're going with this. Again, the conditions were proposed at the mediation to provide some level of assurance to the board as far as the primary and dominant use of education at the property. It was not intended to be a management tool, because if you think about it, in Chapter 48, Section 3, the legislature has said and made policy decisions that there are certain things that zoning should not regulate. Religious uses are not regulated, and bona fide educational uses are not regulated by zoning. And so once the primary and dominant test is met, the zoning board is supposed to take a hands-off position. And just to kind of use an analogy, the zoning board, of course, would never talk about what goes on inside a Roman Catholic church, and similarly, the ZBA would never try to tell the elementary school how many hours of math or how many hours of reading there should be. And we feel that that's kind of where the conditions are now getting, to the point where, and if we could agree, we simply would, but they're actually impeding the educational use. And that's the point I'm trying to make, is that when there's a bona fide educational use, hands off, let it do its business. And we think that we've come to the point where we've demonstrated primary and dominant use, and we're getting too far down into the weeds right now. And finally, to provide the board the assurance, one of the conditions that was asked for at the mediation and was promptly agreed to by the foundation was a requirement that there be an annual report submitted to the board. And so you will continue to have monitoring of what happens. And my suggestion would be that that alone provides the board a sufficient amount of comfort that it's going to get a report every year on what the activities are, and then every year the board can review that. And if the board is persuaded or feels that there is not sufficient educational use at the property, then the exemption can be rescinded. And so my point is to try to, let's give Foundation a chance to run its business and its educational operation without micromanaging it. And I'm sure Attorney Harris wants to say something. That's essentially my presentation, and I don't know how the board wants to proceed about the disagreement on the conditions.
Attorney Wall, you indicated that 10 out of the 16 conditions were agreed upon. Can you tell us right now, just as a running list, which ones are agreed upon, and maybe that will help frame where the discussion goes?
Sure. So coincidentally, number 1 is not agreed upon. Sorry to start off on a bad foot, but number 2 is agreed upon. Number 3 and 4, we are willing to agree to the revised condition, so we're in agreement on 3 and 4. We are not in agreement on 5 or 6 or 7. We are in agreement on 8, not on 9, and on all the rest, 10, 11, 12, 13, 14, 15, and 16, we're in agreement.
Okay, thank you. I think it would be beneficial to hear from town council
Certainly.
at this point.
Good evening, Associate Town Council Pat Harris. I would like to refocus the board, if I might, just very simply on the standards that are articulated in the case that you're all familiar with, which is Regis College versus the town of Weston. And Attorney Wall mentioned one piece but acted as if there had already been an agreement by the board on that, which is the burden is on the landowner to establish to the board that they have a bona fide educational use, not just something they're calling an educational use. It has to be a reasonable performance of an educational purpose. A substantial educational purpose is the language used in Regis. And then if there is a bona fide educational use taking place at the property, then the standard that you're most familiar with is that that educational use has to be the primary and dominant use of the property. The reason these conditions, as submitted by myself and in consultation with two members of the board, address some of the, as referred to as Attorney Wall, micromanagement, is because the goal was to establish a bona fide educational use as well as a vigorous enough educational use that the board would be able to come to a determination that this was the primary and dominant use at the property. I do disagree that the members of the mediation session came away with an agreement to just wait for the landowner to provide conditions. The idea was that the board and the landowner would try to work out some conditions which, if imposed in a grant of an exception, would satisfy the board that those two criteria were fulfilled, that it was a bona fide educational use and that it was the primary and dominant use at the property. I haven't had a chance to go back and look at the special conditions that the landowner is not agreeing to, and I just remind the board that the goal was to have an agreement between the landowner and the board as to all conditions so there would not be continued litigation. In essence, a settlement of sorts, because this flowed from the mediation. The board is free to impose any conditions they feel appropriate, and then the landowner is free to appeal or not appeal. Thank you.
That's a question.
Thank you. Sure.
Could you briefly outline what the area of disagreement is?
You know, I can go through it one by one. I mean, I have on my notes that Attorney Wall just indicated that condition 1 is not satisfactory. And if you look at, I tried to do side by side,
Okay.
yeah. And condition 1, they revised it to eliminate the requirement that was proposed by the board, which is that the number of fellows, i.e. students in the program, would be a minimum of 5. And again, that gets to the attempt by the board to devise a set of conditions that would provide a bona fide educational use. Number 3 and 4, I wasn't clear, but I believe Attorney Wall said those were as proposed by the board. The proposed condition 3, as I've defined it, and proposed condition 4 are acceptable. Okay. And then 5, 6, and 7 are not. 5, proposed condition. Okay, I explained in the comparison that the revised condition by the landowner would allow guests or participants to be overnight guests. And again, the intent of these conditions was to hold this as, okay, there is this request for an exempt educational use. We're going to have mentors and fellows who will be in a 6 to 10 week program every summer. And the conclusion drawn by those of us who were working on proposed conditions was that those should be the only overnight guests. Otherwise, it could be, slip into what was originally denied by the board as a lodging house use. Number 5 also, the definition of of mentors was watered down by the landowner. The board can draw its own conclusions as to why those two things were changed in number 5. Number 6, the condition limited the maximum amount of time that fellows can stay at the Climate House, the proposed condition. And the revised condition expanded the type of individuals who would stay for this lesser period to not only include staff and mentors. There was some flexibility in the condition. It said that the fellows had to stay, for the full term of the workshop. And again, that's one of the things I mentioned in my analysis, is that there needs to be consistent use of the term workshop or educational workshop, because it fluctuates within the conditions, and that creates some ambiguity. But there was also an attempt to be more flexible, because staff may come and go, and that the staff members could stay for not less than 1 business week. And that was eliminated and replaced with a business week, which, as I described in my analysis, can mean anything between 1 and 7 days. It depends on how many work days there are in that particular business week. Again, you can draw your own conclusions as to why that was made more flexible, and whether or not that's appropriate. Proposed condition number 7 has also been rejected. Okay. If you look down at the comparison of the proposed condition 7, which was broken down into 7 and 8 in the landowner's revised conditions, but it strikes out in the entirety limitation on the total number of persons who may reside at Climate House at any one time. And the intent of the limitation imposed as 16 related to the number of bedrooms. There are 8 bedrooms in the property. Again, these are safety issues, and let's just leave it to the board to decide whether or not they think that should be open-ended, or it should be limited in number to 16 or some other number. The proposed condition also prohibited persons not involved in the workshop from staying overnight. Involved in the workshop included mentors, and was substituted with the language of persons participating in Climate House research and educational programs. Again, very vague, not quite sure what that means, and it would allow for potential lodging house use. And I think importantly, the landowner also struck the provision prohibiting advertising of overnight accommodations at the Climate House, which was one of the facts that were of grave concern to the board when, in their original decision, that there was Airbnb and other types of advertising for overnight stays based on bed. If it's an educational use, the advertisement on Airbnb and other media outlets would not seem to be appropriate. Number 9 is the next condition. If I understand this correctly, and Attorney Wall can correct me, number 9 is the next condition that has been objected to. Okay. We were informed during mediation that there would be certain uses of the property, and it's kind of hard to understand unless you actually have a calendar in front of you. But the intent was that from mid-June through, I believe, the end of August, there would be a 6 to 10 week educational program taking place at the Climate House. And then the landowner explained that in May through June, middle of June, I guess, and from September through the end of December, the director and his administrative assistant would be staying at the house. And for the remaining months, January through April, it would be vacant. The house would be closed down because it's not winterized. So this condition 9 limits the use of the property during those periods where the director and his assistant would be there, to limiting it to the director and his assistant only during that period as was represented. That was rejected, and instead was included that the property can be used as a single-family dwelling for all periods of time other than the 6 to 10 week program during the summer. And I just wanted to bring to the board's attention that, you know, a single-family dwelling, there's potential for a use of this property that could expand. For example, the definition of family in the bylaw would allow up to 5 unrelated persons to reside at the dwelling during the off-season. And if you may remember, this property, and there's a zoning issue here that may arise if this is what happens, but if in the future something like this happens, but there is a special permit, excuse me, not a special permit, it's called a use variance that was granted in 1967, allowing for 4 apartment uses. Each one of those apartments is a separate dwelling. 5 times 4, you can do the math. So just think that it's important for the board to be considering all these things. Any other questions?
I do, but I'll defer, because I'm not a voting member.
Any other questions?
Not for Pat.
Okay. Jerry, did you have any questions for?
No, I don't want to belabor this.
Okay. Ken, who did you have a question for?
For Attorney Wall, in particular regarding the issue of condition 9. So if I understand correctly, we have a 6 to 10 week period during which there's a formal educational program. And then we have essentially a 19-week, 3 weeks between May 21st and June 15th, and another roughly 16 weeks between the beginning of September and the end of December, when it's operating as a single-family dwelling. And I was just curious as to what the activities of the, so if we don't constrain this to just the staff, to the director and his assistant, you know, what is going on in that house? Is it just a residence?
Yeah, so the reason why this came about was that our position has always been that the educational use is confined to the summer months. But during the hearing, there were some questions that indicated I wasn't getting that point across clearly, and that it became clear that the property is shut down during part of the year and only occupied by Dr. Von Herzen and his assistant. So I was asked to submit a letter setting forth the schedule, and I did. And it was rather specific with a caveat that said it might vary by a day or two here or there. And basically what the use is that Dr. Von Herzen travels during the time that he's not here all over the world for purposes of the Climate Foundation. And what he does is he comes into town a month or two before the educational use begins. So that's maybe May, early June, preparing the curriculum and getting ready for the activities. Then the educational use occurs, and then it ends after, let's say, Labor Day, and then Dr. Von Herzen and his assistant stay there. And the reason why we just said single-family use was just to provide a little bit of flexibility, because if there's a condition that says it's only him and Ms. Truman, if he has his brother stay over or a guest overnight, it would technically be in violation.
So here's what causes me heartburn. Is this has to be the dominant use, is the educational use.
Right.
According to the statute, right?
Right.
And we have 10 weeks maximum of a formal educational program, and 19 weeks when that's not a requirement, that it be an educational use.
But we're only seeking the exemption for that period of time in the summer. We're not seeking it at any other time. It can be a temporal restriction. So, in other words, to rephrase again, it's not as if we're trying to subvert what the board is trying to do. We just wanted to make sure that if there was an occasional family member or guest that stayed in the fall.
I don't understand how the facility can only be, it's like being partly pregnant. I think it either is an education, predominantly an educational facility, or it's not over an annual cycle. I mean, am I understanding the bylaw or the statute?
No, I think we're on the same page, but the program is run primarily using services
I
of
get that.
students.
And if Dr. Von Herzen and, you know, his assistant were there and they were planning for, you know, half of that time,
Which they are.
and that was, you know, clearly indicated, and then the educational use extends from the time that they're there planning all the way through to the end of the educational program.
I would agree with that.
But that needs to be defined in the bylaw, because otherwise we're saying, okay, you can use this for just 6 weeks and, as an educational facility, and then the rest of the time it can just be a single-family housing, and its predominant use is education. And I don't think that passes muster.
Okay, and I guess it's, I don't want to say it's semantics, but the only reason we objected to the language proposed by the town was just because it was so restrictive that it was to 2 individuals. And we were concerned, being candid with the board, that if there was 1 extra person, we didn't want to be in violation. So I'm in agreement with your analysis. As I said, when Mr. Von Herzen comes into town in May,
So
it's to
really
prepare.
not who's there, it's what they're doing when they're there.
Yeah, and they're engaged in the preparation and planning and record keeping and all the things that go along.
So if
with-
they were there, you know, living there, I think I just would word it differently, I guess.
Okay. And I should say too that we're in disagreement on 6 conditions, but only slightly. That we're very, very close on this.
Well, the other, I mean, the problem is that when you run through all of the issues that there's disagreement on, they all pertain to restrictions that would preclude the possibility of it being used as a lodging house.
I'm sorry, could you say that one more time?
When you run through what it is you object to in these various, you know, in conditions 1, 5, 6, 7, and 9, they pertain to restrictions that would preclude the unfettered use of this facility for purposes other than education. You know, either as a lodging house or a single-family dwelling, or however you want to, whatever other use you want to invoke. And that's, I think that's what maybe causes me a little heartburn.
So maybe there's a catch-all way to do that, to put a further condition that says there shall be no lodging house use, period. Because in the fall, if Dr. Von Herzen is there, and like I said, if he happens to have a family member or friend overnight, he's not going to be charging a fee for that. So.
Yeah, I don't think that's anybody's concerned about that. I think they're concerned about what is, you know, I just would define the period of educational use as extending from the period when planning, and, you know, faculty and the director may arrive, you know, 2-3 months earlier and start planning.
And I think we're only asking for from May 15th, so.
Right, so 3 weeks, fine.
3 weeks,
Or
right?
earlier and start planning. So that's part of the educational program. You've got to make that part of the educational program. And maybe there's a post-program period when people are living there, then they're planning for the next year.
Okay.
But they're not just living it, you know, to enjoy a nice fall on Cape Cod.
Do you want to address that?
I mean,
Okay.
that might be something in addition that they can do, is enjoy a nice fall.
Yeah, and I see exactly where you're going, Mr. Foreman, and I guess what I'm trying to say, and I'm repeating myself, is the intent of saying that was to preclude a possible violation, not to try to expand the use. The property's not winterized, it gets shut down.
Yeah.
And Dr.
No, I
Von
understand
Herzen,
that.
as you can probably tell from all the continuances in this case, he's normally halfway around the world somewhere else, he's not living there, so, do you want to address that further? Okay.
Thank you. So in response to the question, first of all, it takes time to prepare for an educational program, as I'm sure you're aware, both in terms of the preparation in May and June, but then furthermore, the outreach, which our educational program comprises research and other education that actually extends year-round. We've been asked, for example, by the government of Australia and Queensland to provide over 3 years plenary speeches and lectures regarding marine permaculture, which has also been adopted by the Drawdown organization and has been adopted as 2 of the major ways of balancing carbon. And so Paul Hawken has come out as being very strongly in favor of our work, as has the Board of Directors of the Rocky Mountain Institute, and in fact several other organizations. The U.S. federal government has provided us with grants over the past 10 years, confirming our research and other educational use, and that goes so far as to support that we receive from private organizations such as the Gates Foundation and the Grantham Foundation for the Protection of the Environment. So we've established very strongly a very strong research and other educational use. And to answer one of the related questions, if you look at the occupancy of the Climate House, it's very easy to see that it's predominantly and primarily educational because we have so many educators in the summer. And so the ancillary use that occurs when I'm not speaking at the United Nations, when I'm not flying across the country and providing speeches on how do we actually achieve food security, ecosystem survival, and carbon balance, it's the interim time when we're not actually doing that we're using the Climate House as a base for our global operations that include Asia, they include Europe, as well as the Americas. And so from that perspective...
I don't debate any of that.
Yes.
I only say that as this is written, with the modifications that you're requesting to the conditions, it doesn't say any of that.
Very well.
It doesn't say there's any educational use beyond the 6 to 10 week period. And I don't think that is, and if you read that in a literal way, then it's not predominant. Because because you're nearly twice as long, you're there for other purposes.
So we would be happy to document our research and other educational use of the foundation year-round. This is, in many ways, the global headquarters for the Climate Foundation, and our focus has been clear over the past decade or decade and a half. So we'd be happy to document that better, and we are very happy with Ms. Bielen's determination, the board's determination in 2016 that we are in fact educational. And so I would respectfully request that we can add documentation to the fact that we're doing research and other education on a year-round basis.
So, Mr. Foreman, maybe, because obviously the board's going to take this under advisement, and as Attorney Harris said, can write any conditions it feels appropriate. How about a condition that says any use beyond the 10-week educational purpose has to be related to the program in the summer, either through planning or other activities, and a further condition that there shall be no lodging for a fee during that off-season?
Well, that would certainly make me happier.
Okay.
Speaking for me, I don't know how the rest of the board feels.
Just one question for clarification. It's a 6 to 10 week course. Could it be a 6-week course and not a 10-week course?
I think that the 6 to 10 weeks was to provide some flexibility, because one of the things, if we get to talk to condition 1, is it's not the same course every summer.
But the minimum would be 10 weeks, not 6.
No, 6.
The minimum would be 6, and we actually offer, they offer more. So, all right, so the workshops run various different times, and the course runs different. It's not only one thing. There's a course that's taught to the students, and then there's these various workshops that occur that are of shorter duration. Is the course 10 weeks or 6?
It's a variable period from 6 to 10 weeks, and that comprises a set of workshops that include the physical oceanography that we've been doing in conjunction with the Woods Hole Oceanographic, and also the ecosystem biology done in conjunction with our colleagues, in partnership with colleagues at NBL.
And the other reason why it varies is because you might recall that one of the things that we said at one of the prior hearings was that they compete for these grants in these competitive contests for scientific innovation, and their programs vary depending upon how successful or not they are with those grants. And so some summers, like this one, there's less interns than there were last time, and other times there'll be more, depending on what happens during the intervening year. And that's why the flexibility was asked for.
I have a question. Sure. Excuse me. What's going on this week, for example, down there?
So we're preparing for the deployment of the marine permaculture, and so we've got physical oceanographers working on advanced upwelling technologies that enable us to, in fact, design, build, and test the marine permaculture structures. And in addition, we're working on the ecosystem biology in the form of understanding the kelp forest work better and its associated red seaweed growing. So we're looking at the nutrient conditions in conjunction and partnership with Baylor University, and are completing an agreement to partner with Baylor University to study the nutrient dynamics and develop numeric models for the growth patterns of red seaweeds that will be on the marine permaculture.
Okay, I went by there on Monday, around 11:30, 12 o'clock. There was a couple of young guys coming out throwing backpacks in the back of an SUV, and like they were checking out of a lodging facility. And I went by again on Wednesday around the same time, and there was 3 cars there on Monday. There was only 1 car with New Jersey license plates on it there around 11:30, 12 o'clock, and out of nowhere, some guy came walking up and went in the house. But all the windows were all closed in the house, and it looked like it was all closed up and nobody was there. If I didn't see those 3 people over a couple of days. So I was kind of curious as to what goes on. But the real thing that bothers me, similar to Ken, is whether it's 6 weeks or 10 weeks, it's 11 or 19% of the whole year. And it looks like 41% of the time it's used for lodging for you and whoever else is there. And I don't care whether it's family, relatives, or whatever, but it's more of like lodging. So when you got 40% used for lodging and 35 or 8% used when it's closed down completely, it kind of resembles a summer vacation home,
So I'd love to have the opportunity to respond to that. First of all, Dr. Michael Wolovic is a postdoc from Princeton University, the Geophysical Fluid Dynamics Laboratory, and I'm very happy to say that he's become a climate fellow, and his license plate, I'm sure, is from New Jersey. Now, he's relatively young, and he does have a backpack. Nonetheless, he has a PhD and from Lamont Doherty, Columbia University. So we're very happy to have him on board as one of our climate fellows.
It's just the appearance of driving by and seeing it.
Yes, well, our program is focused on doing this research and other education, and furthermore, by looking at the occupancy of the climate house, I think it's quite straightforward to see that, in fact, most of the occupancy is related to the research and other educational use that we are performing. And so from that perspective, all of our participants are, in fact, scientific, educational, and focused on the climate issues that we need to try to address with marine permaculture. And so from that perspective, the occupancy makes it completely clear that the use is predominantly educational.
Okay, one last question. In the department, inspection departments here went down and made some inspections. Have all those deficiencies been corrected?
They're in the process of being addressed with the building department, and I expect that as part of our resolution, we'll have those completely addressed as well.
All right, that's
Thank
all
you.
for now.
Anyone else with questions? So I have a couple. Attorney Wall, regarding condition 7, maximum amount of people were 16. And I believe you proposed striking that out in its entirety. Can you tell me why?
Because the capacity of the property is in the range of 20 to 24 when all the bedrooms are counted up. And my client felt that that was unduly restrictive, and we're suggesting simply that the occupancy should be defined as it normally is by the building department or the health department.
Okay. Because this gets more into the territory of what you traditionally look at as a board, regarding parking, regarding safety issues of the building. If you were to have 20 to 24 people staying there, I'll just address parking for right now. Have you made any attempts with either the town or private landowners around Woods Hole to make any sort of parking arrangements? Because
No, because we're waiting to see how this turns out, whether we're going to succeed in getting the exemption or not. But to the extent that we've addressed it during this hearing, you know, what we've said is that many of the people that are coming come from far away, and they take public transportation and they use bicycles. It's also a grandfathered situation. I mean, it is what it is. The house, I think, was built in the 1880s or 1890s. It has inadequate parking, there's no doubt about it. One of the conditions that's proposed and agreed to is that your zoning bylaw requires even exempt uses to go to the planning board and go through site plan review and obtain whatever waivers are necessary. And so I'm presuming that if we get through this exemption process, that we'll have to do that, and then that board can attach conditions about where parking can occur and where it can't occur.
thank you for addressing that. Turning to condition 1, the minimum amount of fellows were proposed at 5, and I believe you countered with no minimum amount.
Right, and so I have two comments about that. So the first, I harken back to what I had responded to Mr. Dugan just a minute ago, is the program varies year to year based upon the funding that Climate Foundation is able to get from its competitive work. So putting 5 there might not work. And secondly, during the mediation, the retired land court judge, Judge Lombardi, had a tremendous idea. It's not really the raw number that matters, it's a percentage. So in other words, if there were 5 people in the house and all of them were 100% engaged in activities of an educational nature, it would be 100%. So we would suggest that the condition we proposed satisfies the primary and dominant test, and/or we could add a percentage there that says it's never less than a certain percentage.
Thank you. Does anyone else have any other questions? Suri, any questions?
No, thank you.
Okay. I guess we can turn it over to public comment if anyone does have any questions, comments, concerns regarding this.
Before you do, Mr. Chairman, could I just 2 extremely quick comments?
Yes, you can.
The disagreements on 5 and 6 are very minimal. The disagreement on number 5 was that the board asked that the language be revised to make all mentors have a PhD. And the issue with that, from my client's perspective, is not all mentors do. One of the things that the Climate Foundation does is makes documentaries, and so they have journalists and filmmakers coming to the property to help the students learn how to appear on camera and how to make a good documentary that people will want to pay attention to, and they don't always have PhDs. And this kind of gets into the comment I meant about, and I mean it with all due respect, but how the town is trying to get too far into the management of the process. Besides the PhD requirement, we're in complete agreement with condition number 5. And in condition number 6, it's the 1 business week. We simply would ask that the week be defined as 4 days and 5 nights. We're not asking anyone to come in for a day or 2. That was one of the big issues from the get-go in this matter. But 1 week implies 7 days as opposed to a business week. So as I said, some of the disagreements are very minor. Thank you.
Thank you, Attorney Wall.
Could I ask a clarifying question?
Yes, you may.
When you had said that you don't, the number of fellows you're considering videographers and audio people as people that could assist. So could you put something down there, 5 fellows with the exception of additional multimedia support staff for educational purposes, or something along those lines that you had just said. They're there to teach the students how to do proper documentation.
Right, so that condition does go to exactly what you're saying. There's one condition about the fellows, and then condition number 5 says, other than the director, his or her assistant, and other than the fellows, overnight guests shall be prohibited unless they're a mentor. And then mentors must have PhDs or be duly qualified PhDs. That phrase is the only issue that we have with that, because the mentors can be other than PhDs. They can be the journalists, they can be the filmmakers that are all involved in the mentor program and interacting with the fellows and interacting with the director, because one of the conditions says no one can stay at the property unless they're part of the program.
But why can't you specify the mentors as being media professionals.
Oh, we could. One of the difficulties that we've been working through this process is because you can only meet in an open meeting, we've had continuances, and we've had to work this out in this kind of, almost like Congress passing a law. And I know there was a holiday week, I'm not throwing anyone under the bus, but I only got this yesterday.
Okay,
So,
fair enough.
Anyway, thank you.
Thank you. Guess we can turn it over to public comment. Does anyone have any questions, comments, concerns regarding this? Seeing none, I guess we can turn it to board discussion. Does anyone want to start us off?
Yeah, I'll just for comment, so going over the different conditions that they're contesting versus what were proposed, it just does not appear that the educational use is dominant or primary. I mean, all these changes that could allow guests or lodging house facilities or timeframes or, very vague and ambiguous statements, it almost sounds like you're trying to fit certain sections of the year to meet an educational use just to get an exemption for the property for that short time frame. And if the educational use, the property should be used just for educational use. There shouldn't be situations where we're looking at it being used as a single-family residence, or now there's a guest that comes for a small period of time, but it's not during the summer months, it's during the off-season. It just doesn't make sense that this is a primary dominant use as for educational. I understand there is educational going on, but I don't see how it's primary and dominant. I also don't understand the fact, the comment about grandfathering on maybe parking when they're changing the use to an educational use from a residence. So is that grandfathered? I mean, as far as I know, it isn't. It just seems that this just gets, the more we go over this over and over again, it's just more loopholes versus anything concrete that just defines it as a primary dominant use.
I mean, this has turned into this hybrid situation that, is problematic for me. If I were the building inspector in Falmouth and this scenario were presented to me for consideration as to whether or not, as proposed, that, to make a decision on this, I wouldn't go near it. I wouldn't go near it. I agree with Bob. Concerning the Climate House and at this location, I don't think they're in a strong legal position. Attorney Wall's done an excellent job with what he's had to deal with, but yeah, no way. I wouldn't go near it. You'd be at the Board of Appeals, which is where we are. So I'm as proposed, I'm not in favor of this at all. I don't think.
Oh, sorry. I didn't
No,
mean to
that's
cut
okay,
you
yeah.
off.
I can't get there.
Ed, any comments?
No, I still think it's, somewhere between 11 and 19% is stated that it's the use for the educational purpose, and the rest of it's a residence.
Right.
And I don't see how we could approve it.
And I just echo the board's concerns, the whole temporal aspect of being a primary and dominant use. It's like you said, Paul, it goes sort of to a hybrid, much like the Regis case. Okay.
Yeah, I think I think we sat down and we tried to provide what we thought was a set of conditions that were rigorous enough that we could justify this. And they came back with a set of conditions that watered down all those requirements to the point where exactly what all the other board members have said is the case. And I can't support it either under the current, what's proposed by the applicant.
Could I ask a question of the board?
Sure, Jerry.
Don't look at me like that, Jimmy. If adequate language could come up with, they suggested some language that didn't come out in mediation, and that might be frustrating because it didn't come out. But is the board saying, based on what they heard tonight, that there's no way they could tweak the language to be satisfied.
Well, I mean, I understand what you're saying, but it shouldn't be this difficult.
Okay.
In my opinion. No, it's reasonable to say that, but I just think that it just shouldn't be this difficult. A list of conditions a mile long, I mean, this is turned into a rocket, and it shouldn't be. It should be a fairly simple test, and I don't think it's simple at all. And it's been perverted to the point of insane.
This has been a long process, too. I mean,
Yeah.
it hasn't been a short process.
That's true.
And they've come back tonight with something, like Ken said, that the contested conditions, they've watered everything down. You're almost going back to what they started with as a lodging house again.
And, I think the important point is that it goes beyond the Climate House. This is we're setting a precedent here. There is a lot of educational research activity in this community, and we want to be careful not to open the door to, anyone being able to come along and say, okay, I can be exempt from zoning, or, if I do this, this, and this. So, I guess the question is, do we want to close the hearing and proceed, or?
Before you do that, may I have one question? I know which way the wind's blowing. Would the board be inclined to approve it with the conditions as Attorney Harris submitted?
Those were conditions that we hashed out during the mediation in an effort to ensure that they met what we consider to be the minimum standards for justifying the educational use. And, I think we were bending over backwards to try to accommodate them. I would be okay with those, personally.
How does everyone else feel about that?
I would not.
I still don't think it's the predominant primary use. It appears to be 40%, 41% lodging and somewhere between 11 and 19%, for the for the proposed educational use. And, I mean, it's like 2 to 1. It's not the primary or predominant use.
All right. Well, I tend to agree with Ken.
How many do we need to deny it or pass it?
I'm a no.
And I'm a no.
It has to be a 4 to 1.
It has
4 to
be
1.
4 to 1. I'm not voting, so,
You're not
No, I
voting.
know,
Right.
yeah.
I know.
But I guess the other point I'd like to make is I think we have spent a lot of time on this, and I think it's time to bring it to a close. I
Yeah.
think, so if what we're hearing is that the board, even if we adopted the conditions that we mediated, is still 3 to 2,
3 to 2.
then this isn't gonna go. And let's just take the vote, close the hearing.
Is there a motion?
So motion to close?
Motion to close.
Second.
Made by Bob, second by Ed. All those in favor?
Aye.
Aye.
Aye. Anyone like to propose a vote?
I would move, yes, I would move that we, in accordance with the original provisions proposed by town council, vote in favor of this.
And I'll second that. Or can I second as a chair?
Yes.
Okay, I'll
Well,
second that motion.
I mean, the way the wind is blowing,
Right.
it's the only second there's going to be.
Well, just wanted to make sure.
It's usually a
With procedure.
tiebreaker.
Okay, you're the chair, so you have to call the vote.
All right. All those in favor?
Aye.
Aye.
Opposed?
Opposed?
Oh, wait a minute.
Well,
No.
let's call
Do you
again.
want to do it again?
Let's do it again.
I'll take every vote I can get.
All those in favor?
Still 3 to 2, Brian.
Aye.
All those opposed?
Aye.
Opposed.
3. Motion does not carry 3 to 2.
I thank the board for all the time, in particular the board members that attended the mediation and worked with town council on the conditions. I know this was an arduous one, so thank you.
Thank you, Attorney
Thank
Wall.
you, Brian.
All right. I'm gonna
Okay. Okay.
Can you take a 5-minute break so I can speak?
Good idea.
Yes, we can. We'll be taking a 5-minute break and coming back shortly. Yes, it is.
Let's go.
That can't go any higher?
All right, and we are back from our 5-minute break, turning back to the hearings list. Now we have application 3918 Crowell Road LLC.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Massachusetts General Laws, you are hereby notified that 66 Crowell Road LLC of Chestnut Hill, Massachusetts, applied to the Zoning Board of Appeals for a special permit pursuant to Sections 240-3C and 240-68D of the Code of Falmouth to raise and reconstruct the pre-existing non-conforming single-family dwelling on subject property known as 66 Crowell Road, East Falmouth, Massachusetts. For referrals, from engineering, it was the standard, this application was reviewed only for impacts to public right-of-ways and public utilities. Crowell Road is a private right-of-way in this area. Any connections or alterations to public utilities would require permission from the appropriate town department. The project must not direct any stormwater runoff to public properties, abutters, or rights-of-way. Dry wells are proposed for the roof. Health, proposed septic system is properly sized and located. A permit for this proposed septic system has not been applied for at this time. Fire department had no comment. Water, no town water to this property. Planning had no comment, and assessors had no comment. There was one letter of support, and there was an email from Rod Palmer, the building commissioner, saying that he met with the designer and does not consider the proposed addition to be does consider the proposed addition to be part of the principal structure.
Excuse me, Mr. Chairman, could you
Yes.
designate an alternate as a voting member?
That would be Bob Dugan. And for the applicant?
Good evening. My name is Michael McGrath. I'm a registered land surveyor and professional engineer. I work for Holmes & McGrath. My firm has has prepared the site plan, and that I've colored up. I've also given you 11 by 17 copies of this colored plan. The site is located off of Crowell Road, which is a road off of Davisville. The parcel is a significant size. It's acres. There's an inset up here that shows that it's about 1.5 acres. It's 68,000 square feet. There's an existing house that I show dashed on the outline. And what the proposal is to tear down that house and build a new house. The new house is shown on the colored it's colored in the location shown. Under the Falmouth zoning bylaw, there is a minimum setback from the waters of Bourne's Pond, which was defined as a certain contour. And the contour was defined under the NGVD, which was the former datum used from mapping, which was also called mean sea level. The government's changed the datum, so now it's called the North American Vertical Datum, NAVD of '88. It's the datum that relates to the satellites. And so we've converted from one datum to the other, and we identify on the plan that elevation 3-foot NGVD is equivalent to an elevation of 2 something. It says in the plan 2.4, I think. I can't read it that far away. Under the zoning bylaw, the principal structures are supposed to be 50 feet setback from the waters of our estuaries and from all of our, basically, ocean waters. And in this case, the existing structure is much less. It's a total of 20 feet to the principal structure. We're moving the house back so it's 32 feet. Under the provisions of the zoning bylaw, we can apply for a special permit to basically alter a pre-existing non-conforming structure. We can extend it, alter, or change. And what we're obviously proposing is we're tearing the house down and building a new structure. So in order to get a special permit, we have to meet certain tests that are defined in your bylaw. Is the site adequate for the intended use? There's been a house here since the 50s. The lot is, as I said, 68,000 square feet. It's adequate in every way to be a home site. The lot coverage is increasing very slightly, but it's less than 6.5%. The maximum in the bylaw is 40%. So obviously this is an appropriate use. We won't have any effect on traffic flow. That's one of the standards in the bylaw, because a single-family house is being replaced by another single-family house. We're not going to have any impact on the visual views from the neighbors. One, it's a pretty isolated lot, and further, we're further back from what is the most beautiful part of the site, Bones Pond. It's going to be connected to a new Title V system, and you heard the health agent say it was appropriate. There's adequate utilities on the site to service it. Give me a second, my fingers are too thick. We're not going to have any effect on affordable housing because we're taking one house down and building another. We don't need any planning board approval, and we think that it's in harmony with the intent of the zoning bylaw. As far as the state law, we have to have basically, there's a standard that there be basically no adverse effect. So I believe that we meet all the standards for for this to be approved as a special permit. We have gone to Conservation Commission. They have voted in order of conditions approving this work. So I believe that this is an entirely appropriate special permit application, and I'm here to answer any questions.
Thank you. Are there any questions from the board? Bob, do you want to start us off?
No questions.
No questions. No questions.
Jim, any questions?
Sure, so it's presently 4 bedrooms, is that correct?
Oh, sorry, I don't know that answer. We have, the septic system is designed for 5.
Is that a new septic system that's going in?
Yes, it's a brand new Title V system.
Okay. And I saw the present, total height of the structure presently is 22 feet, is that correct?
I believe it's whatever's in the, listed in the application. Yeah, that would be an appropriate description.
And what's the height of the new structure?
I don't have a copy of the house plans, but I looked at the house plans.
Yeah, I was just trying, I'm sure it's on it, I just
Yeah.
want to confirm it. So right around this area.
He's showing,
So right around this.
he's showing just under
See.
28 feet. Hold on.
Yep, 6.5 inches.
So 28, 6.5.
Yeah.
Yeah, he's showing it to be less than 29 feet. There is a cupola or a chimney that sticks above, but that doesn't count. So it's just under 29 feet.
And the garage is connected via, is it an enclosed walkway?
Yes.
And what's the proposed use, I guess, of the room above the garage there?
I'll have to look at the,
Michael, do you want my
Yeah, I just don't think it's.
Looks like it has a bed in it.
I don't know if it designates it on here unless I missed it.
No, it just shows a,
it's been counted as a bedroom.
yeah, it shows a bed in the
Okay.
picture.
It's okay. Yeah, this is what I printed, so I don't know if it's, if I've
It
got
meets
every
the
sheet.
criteria of a bedroom.
Bedroom and it's being counted, then
Yeah,
included.
it's being
Okay.
counted as a bedroom.
Well, then that answers the question.
So that means we have 5 bedrooms?
Yes, we have 5 bedrooms.
And the only, I guess, the reason that you're here is because of the existing deficient setback, which you're improving.
Right, the only non-conformity is the minimum setback off the water schooling pond.
Thank you.
Kim addressed a lot of the questions I was going to ask, but regarding the engineering referral with the dry wells, I do see that some are listed on the plan that you just submitted. Can you walk us through those?
The Conservation Commission requires that every house within jurisdiction have dry wells to drain the roof. So there's a dry well here, there's a dry well here, there's a dry well here, and then there's a dry well over here. So there's been enough dry wells to drain the surface runoff from the roof. There's also one over by the garage and the second one over here. So there's plenty of dry wells.
Great. And a follow-up question to the height of the proposed structure. It is going up a few feet. Is that related to being in the FEMA velocity zone, or are you just going up anyway?
We are not in a floodplain. This is the velocity zone that's on the coastal bank. We're in what's called an X, which is basically it's above the 1 in 100-year storm. So it's not related to the any requirement of FEMA, but it's just the design of the house. They could go up to 35 feet under our bylaw.
Mhm. All right, that does it for me. Jerry, any questions?
No, in the past, we were concerned about total height, including cupolas.
No, cupolas do not count, they never have. Cupolas and chimneys have never counted in the height of a structure.
Okay, so there must have been a lookout on a previous,
Yeah,
okay.
yeah. We have that opinion from the building commissioner on file.
Just a follow-up to that bedroom above the garage, that's just intended for use of the property owner on site, no intent to rent that out separately, like as an accessory apartment?
It cannot be an accessory apartment as is drawn.
Right.
Because the accessory apartment requires
A kitchen, yes,
So it's just another bedroom.
right.
Or
But
it
that's
could be
the
a-
intent as
Could be
well.
a game room, family
Okay.
room, could be anything.
You're not
It's
answering.
just under the code, if you have a house, I'm sorry, if you have a room with more than 70 square feet and a one window and privacy, it's a bedroom.
And no intent to use that as an accessory apartment?
Yeah, we would have to apply for that.
I-
We did
I
not apply
unders-
for that.
I
so
understand that.
You can write a condition
I've been on the board long enough to understand that you would need to apply for an accessory apartment. I'm asking what the applicant's intent is. Thank you.
Well, our instructions were to apply for this particular use, so I don't know what their long-term goals
Okay.
are, but if they wanted it to be an accessory structure, they have to come back.
Thank you.
So a quick follow-up question regarding the septic. I see that it's under the proposed shell driveway, so that's going to be rated good enough to drive over since it's in front of the garage?
Yes.
All right, great. Any other questions from the board?
No.
Sari, any questions?
Nope.
All right, turn it to members of the public. Any questions, comments, concerns regarding this application? All right, seeing none, back to the board. I think we might have enough information here. Does anyone want to make a motion to maybe close the hearing?
Yes. Make a motion to close the hearing?
Second.
Motion was made by Ed, second by Paul. All those in favor?
Aye.
Aye. And what would the board like to do?
I'd like to make a motion to approve application number 39-18 as submitted.
All right,
Second.
second by Ed. Go on to findings.
Paul, you made the motion.
The findings, yeah, it's, the proposed new dwelling unit is further away from Bourne's Pond than the than the existing structure.
So I think that we should make a finding that the only existing nonconformity is the setback, the minimum setback off Horns Pond.
Yeah.
That's presently 20 feet, and they're increasing that setback to 32 feet.
Perfect.
Any other findings?
Yeah. Findings that the number of bedrooms will be 5, that they're installing a new septic, consistent with that use.
Not more detrimental.
Not more, yeah, not more detrimental to other lots.
Meets 242-16.
242-16.
The intent is not to use it as an accessory
I
apartment.
don't think that's what was said. That's what I wanted him to say. I don't think that's what was said. I think what was said was they haven't applied for
So
an
we'll-
accessory apartment.
So the board can do
So-
a condition.
Right, and I would say, but I think we do need a finding. I would just say that finding is, as proposed, there's no cooking facilities above the garage. Good, because I wanted to include that. I didn't know if anybody else would want to.
I think that's a good way to address it.
Okay.
Yeah, and I mean, it might be helpful to have a finding that this is it's a large lot, and lot coverage is pretty minimal,
Very low.
yeah. Looks like a nice project, so I'd say conditions are what, per plans, no cooking facilities, above garage, not to exceed 5 bedrooms.
Anything else?
Do we need as-built?
Per plans.
Per plans is fine.
Plans. Yeah, I think we usually just require as-built when it's like close to a,
Close to the
like a
limit, the
10-foot
height.
setback, and, yeah.
All right, I think that just about does it. That motion was made by Paul, second by Ed. All those in favor?
Aye.
Aye.
Thank you.
Thank you very much. Welcome.
Thank you.
All right, and moving along, we have application 42-18 Sherlock, 36 Lake Lehman.
Mr. Chair, I'm going to recuse from 4218.
Okay. Bob is recusing, and Jerry will be sitting on this application.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Massachusetts General Laws, you are hereby notified that Joseph T. Sherlock III of Falmouth, Massachusetts, applied to the Zoning Board of Appeals for a special permit pursuant to Sections 240-69E and 240-3C of the Code of Falmouth to construct a detached garage exceeding 20% lot coverage by structures on subject property known as 36 Lake Leaman Road, Falmouth, Massachusetts, for referrals. Engineering had its standard comment. They also note we recommend adding dry wells, rain garden, or other stormwater measure for the roof. Health commented that's on sewer. Fire department had no comment. Water said not applicable. Assessors had no comment. Planning had no comment.
Okay, and for the applicant?
Good evening, Joe Sherlock, 36 Lake Leaman Road. Going to put up a 20 by 24 detached garage in the backyard. Meeting all requirements, under 18 feet high. I'm not sure what else I need to go forward.
All right. Let's turn it to board questions. Jerry, you want to start us off?
No, I think it's very well done, I think. Can support this, and we'll probably ask that, above the garage, so we don't have a little space.
No, it's just an 8-foot loft up there.
No.
All right.
Dry
Okay.
wells aren't on there, but there will be dry wells.
Kim, any questions?
Yeah, so the property right now, it's non-conforming on the side, the residence, the structure. It's not conforming on the
On the opposite side.
Yes,
of
on
where
the-
the garage is gonna
Okay.
be. It's within 7 feet of the lot line,
okay, and then the front yard setback as well?
yes.
Okay, so to get to, I guess describe the use if you could. How are you planning on?
I was gonna put a shell driveway along this side. There's 10 feet on the left side of the property, 10 feet 3 inches. So it's a tight squeeze through there, but I'm not gonna use it that often. I'm gonna store a classic car back there and, lawnmower, snow blower, things like that. So I'm not asphalted over at the side. I'm gonna put crushed shell. If you've been by the property, I maintain it pretty well. I think it'll look okay.
What's the height of the residence?
The height of the residence, I'm not exactly sure. It's built in the 50s. I would say, around 20, 22 feet. It's a 3/4 cape. Upstairs is not used. It's unfinished, attic. 3-bedroom.
And I saw on the plan for the garage, you're going to be, is there separate storage space too, to the right of where the garage is? Or the stall is?
Yeah, it's a single car garage, and then on the right is a engine storage, store garden tools, and like I said, lawnmower, snow blower, things like that. So a single car garage.
Right there.
Yeah. Any heat?
No. Nope.
Okay, that's all I have.
Ed?
No, I have no questions.
No questions? No.
And just for the record, you're removing the existing shed that's basically in the
Yes,
same
taking it
spot?
down. Taking it down.
Any other questions from the board? Sari, any questions?
No, thank you.
Okay.
I do have another question.
Go ahead.
Did you discuss at all with your neighbors about installing this garage? Have you talked to anyone?
Not every single one of them, a
Yeah.
couple of them. Helen Ahern on the left, yes, knows. Mickey Toole knows. A few of the neighbors in the area.
Okay.
It's a lot lower than a lot of the structures around me. There's been a couple homes, directly behind me and to the right that have been built that are good-sized homes.
Okay. All right, thank you.
All right, no more questions from the board. We'll turn it to members of the public. Any comments, questions, concerns? Anything for this application? All right, seeing none, it's a very modest project. What would be the pleasure of the board? Close the hearing?
Make a motion to close the hearing?
Second.
Okay, that was made by Ed, second by Jerry. All those in favor?
Aye.
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 And how would you like to proceed?
So I know I'm going to be the only one saying this, but I'm not in favor of the project. I actually don't. I think it's the project already. I think there's non-conformities on the front. I think adding a driveway in that 10-foot space, as he said, is going to be a tight squeeze. I just think it adds bulk to the rear of the property, and I just don't like it. But that's for reasons under the bylaw. I just don't, and I understand that it's increasing the utilization for the homeowner, but I think that it's too much for that size property in the site. Saying that, I understand probably everyone else here will feel differently, so I'm happy if he
It's
gets his
closed.
permit,
It
but
is-
I'm
Oh,
saying
The hearing is closed.
personally,
Sure.
I'm just not
Yeah.
in favor of this, but that's just.
Everyone else like to chime in to?
I'm fine with it.
I'm fine with it.
All right.
I'm fine with it.
Jerry? Okay. And I'm fine with it as well, so. Would anyone like to make
I'd
a motion?
like to make a motion to
the project?
approve application 42-18 as submitted.
I'll second it.
It was made by Paul and second by Jerry. Paul, would you like to make any findings or conditions? I don't think Kim's gonna help you this
I
time.
don't think so.
Well, it's consistent. It enhances the utilization
Yeah,
of
I
the
mean,
property. It's
we-
not more non-conforming.
It creates, the setbacks are not any more non-conforming,
This-
is what you're
that'd be-
saying.
Yes, that's what I meant to say, thank you.
And the proposed setbacks of the garage are conforming.
Yes,
It's gonna remove the shed.
yes.
So, 20 by 24 feet, 18 feet high, with an 8-foot loft up on top.
Mhm.
No heat.
Under 240-69E, does it meet that criteria?
It better.
You want to add that to the finding?
I
Yeah.
would like to.
Thank you.
Any other findings?
Gonna have a crushed stone driveway, or whatever it is,
So impervious?
pervious, yeah.
Applicant did state that he was amenable to adding dry wells. Any other findings? Conditions per plan. And Sri, I guess we'll add that language regarding dry wells per the applicant's engineer.
Well, you want to add, you want dry wells added and location appropriate by engineer?
Yeah,
Yes,
Land
please.
surveyor?
I think that just about does it. Anything else, Sri?
Garage is not habitable? I'm not sure. I might have thought.
I'm sorry?
Anything else that we should be considering? I think we're just about there.
Well, there's no heat in it, so it can't be habitable.
Right.
Okay.
So do you want a condition that there's no heat, since he made the finding,
Might as well,
Or
but
so he made-
back up that finding, sure.
so it can't be, okay? Then that's it, I believe.
All right, that motion was made by Paul and second by Jerry. All those in favor?
Aye.
Aye. And do we have any opposed?
Oh, sorry, I striking my comment.
So it's 4-1.
4-1.
Thank you.
You're welcome.
Thanks for your time.
Up next, we have application 44-18 Wonderly, 422 Davisville Road in East Falmouth.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Massachusetts General Laws, you are hereby notified that Martin Alexander Wonderly of East Falmouth, Massachusetts, applied to the Zoning Board of Appeals for a special permit pursuant to Section 240-3A and 240-3C of the Code of Falmouth to acknowledge that two separate dwelling units existed prior to May 19, 1959 on the subject property known as 422 Davisville Road, East Falmouth, Massachusetts. For referrals, we have, Fire Department had no comment. Engineering attached your photocopies of original aerial photography available in our office. It appears that there were two buildings at this location in 1950. Assessors had no comment. Health, existing cesspools serving both dwellings, okay, as there is no proposed increase in flow. Planning had no comment, and Historical Commission had no comment.
For the record, there's information submitted by people that state that they are very familiar with the property, that the two dwellings have existed prior to May 19, 1959. You have the photos from engineering. The applicants strictly want to renovate so that I believe somebody's ready to have a baby, and they're, and this would be a place for the parents to stay, although there should not be any conditions as to who can stay there, because if the board finds, as the information states, it existed prior to May 19, 1959. So, and with chairman, designate an alternate?
This worked out nicely since Bob had to sit out the last one, so I'll appoint him for this. So we went Bob, Jerry, Bob.
Thank you.
All right. And for the applicant?
Hi, my name is Martin Wanderley. I'm owner of the property. I'm with my spouse, Amanda Spivak, at 422 Davisville Road. As Ms. Boudreau stated, we're trying to get this structure acknowledged as a second dwelling on our property that was used as a residence prior to 1959. It needs a little bit of work interior, some painting and flooring. We've been using it since we've owned the property as a kind of an art studio and workshop, and have had some visitors staying there with the family that are in the family. We weren't quite sure on the regulations as far as having it approved until looking further into it. So we wanted to have this special permit from the zoning board so that grandparents can come and visit, and we have some brothers and sisters that would like to come up and visit us. So I do have a few letters the administrator had already stated from. One was a prior owner, the Pratt family, from one of the children of the Pratt family. I don't know if I should read it to you, and then.
They're in the file.
Okay.
Everybody's reviewed it.
Okay. The other letter was from that was Peter Pratt, was one of the family members that stated that his parents moved into that building in 1944, actually, when they were first married, and then he had some aunts and uncles that stayed there in the 1950s. A neighbor that lives down the street, Miss Phyllis Cogswell, grew up in the neighborhood, and she said between 1955 and 1960, she actually played with the Pratt children in that house while the Pratt relatives were staying in it. So this would have been between 1955 and 1960, and I believe she would have been between the age of 5 and 10 herself. And she signed that letter. I don't know if I don't think the photos of the barn cottage were submitted, but we have an email from Peter Pratt's sister, Barbara Keefe, and she just states that these pictures were taken in 1946. If I could submit an additional.
You can give them to
You
the
can
clerk.
give them to the clerk.
Kimberly.
Thank you.
The first photo is of Peter's father, his grandfather. Yeah, I think this is his father. Oh, yeah. Yeah, Peter and Kimberly's father are standing in front of the cottage in 1946. So we also were given some ancient field cards to the property that suggest that the main house was 200 years old, and I think the date on the field card was 1976. And then they suggest that the barn cottage was used as a dwelling they labeled it barn dwelling, and they said it was 75 years old. But I think these field cards are on record, so
They are.
I think they were submitted in the package. And that's all that I have. You can take that into consideration.
All right, we'll turn it to questions from the board. Bob, you want to start us off?
No, no questions.
I just have a question. Has it been used continuously and uninterrupted?
Yeah, as far as we know, the prior owners, well, the Smiths, they were owners, actually when Pratt owned it, it was 15 acres to the pond, and then Lloyd owned it for a short period. He subdivided the property, and that's how you got Captain Davis. Our parcel ended up, being cut down to less than an acre with the 2 dwellings on it. Then the Smiths bought it at that time, and they used that whole property for 8 children that they had.
But the cottage specifically, I'm asking. Has it been used continuous and?
During our ownership?
Continuous and uninterrupted since 1959?
Yeah, as far as.
So there's been no lapse of use associated with it at all?
No.
Primarily during the summers, but there was no lapse for 2 years.
Yeah, that was my question, that's all. Yeah.
Sure.
Just a general question, thank you. I'm all set, thanks.
No questions.
So I'll just jump on Paul's question, just because the bylaw requires credible evidence. Is there any way that you could get something, an affidavit or a letter from the Smiths that you're referring to say that they used it for that period?
We don't have contact with them anymore. I mean, we could try to get in touch with them somehow. I know that one of the 8 children in the Smith family was Gibson Smith, and he was the one actually living in it prior to our ownership. Yeah, I don't know how to get in touch with the Smith family.
I believe Gibson is probably the only one that's left, and I'm not so sure that, is he here? I don't think he's here anymore.
No.
I happen to know him.
Yeah.
Okay. And then just for renovation, so you're just doing interior renovations?
Yeah, it needs a new floor covering, and then there might be a few windows that need replaced and some painting inside.
How long have you owned it for?
Since 2011. That's 7 years.
And during that time, you've intermittently used it as a dwelling?
Yeah,
Okay.
yeah, we've had family visiting.
And then I'll just follow up. So how did you, I guess, you said when you were speaking that the Smiths' prior owners did use it as a dwelling. So how did you come to that knowledge, I guess, was there?
Well, yeah, actually Gibson was in contact with us during the purchase and sale, and shortly after we bought it, there were some items that he needed to retrieve from the cottage. There was a cable box for television, his mother's vacuum cleaner, and items. I don't know if the appraiser's report was submitted.
It's just the cover page.
Yeah, I could pass out the appraiser's photos from when we purchased the property.
I think
if you
that would
want
be
to see that.
good to have, yeah. Thank you.
It focuses, the pictures I grabbed were the three structures on the lot, and most of the interior photos of the cabin. There might be one random picture on one page that's in the main house, but they're labeled. So
Yeah.
you can see the kitchen and bath, and bedroom.
Okay. Thank you.
Regarding the Board of Health referral with the septic services, both the main house and the cottage, they mentioned so long as there's no increase of flow, they should be fine with it. You're not anticipating any increase?
No, we're keeping it at 1 bedroom.
Great. Does it for me. Jerry, any questions?
Getting back to what Jenny Cumberland was bringing up, Were the field cards from the town, or were they just field cards that you found?
They came from the town.
Okay, thank you.
Yeah.
And what year were those field cards? They might be from various years.
1956, they're in the file.
Yeah. I couldn't quite decipher
Yeah,
that, but.
it's very tiny on the right-hand side on the one page where they do the assessment.
Sure.
I think it starts, and at the top it tells in 1956 what the age of the structures were. It's in our file.
Thank you, Sari.
No other questions.
Okay. Any other questions from the board?
Not here.
All right. Any members of the public, any questions, comments, concerns regarding this project? All right, seeing none. How would the board like to proceed?
Can we just talk about this credible evidence? I mean, I think the appraisal and certainly the photos of the cottage show that it was being used as a dwelling, certainly at the time of sale. I know how difficult it must be to get this information from prior to 1959, because it seems like every application at this point is so difficult.
Well, they've got the letters from the Pratt family
They
and the
do.
Smith family who have owned it consistently.
Well, that's what I'm trying, so
prior
the Smith family, I
to-
guess, is that, because it was Pratt and then Phyllis Cogswell, but I didn't see anything from the Smith family. Unless I'm just, so that's my, we
Well,
have,
I know Gibson's lived there for quite a while.
so, but I think it's an approvable project or, application. I just am a little, that's the standard. But we do have the photos showing it being used. It looks clean. It doesn't look unkempt or anything like that. And we have their testimony saying that that's what their understanding was when they purchased it. So I think we can go forward.
Yeah, it's just tough to, 1959 always gets further away, and, you try to get this information, but at the end of the day, you
This is one of those
do the best
bylaws
you
that need to
can.
be redone.
All right.
Yeah, I mean,
Those get tougher every year to prove.
yeah, I just wanted to ask the question, and
Yeah, I think it was.
As far as that standard goes, which is a variation of that legal standard, a preponderance of credible evidence, I think everything they provided, I think they're there.
yeah,
I think they've proved it.
I agree.
Anyone else like to make any other comments before we move forward? All right, seeing none, how would the board like to proceed?
I'd like to make a motion to close the public hearing.
Second.
Motion to close, all those in favor?
Aye.
Aye. Anyone like to make another motion?
I'd like to make a motion to approve application 4418
Second.
as
You can have a
submitted.
seat.
It's made by Paul and second by Ed. Moving on to findings.
I mean,
I think we're going to make findings that there were letters submitted,
The engineering photos.
engineering photos submitted showing that there were these two structures on the property, that there were letters submitted from people who had firsthand observations of the use of the dwelling prior to May 19th, 1959, that the testimony of the applicants was that it's their understanding that this was used consistently as a dwelling from 1959 to the present, or till their purchase, and that they have used it, have not abandoned it or not used it for 2 years since owning or since purchasing the property. I think it's also that there was this appraisal submitted showing the cottage to be in good condition as a dwelling upon their purchase in 2011.
We've got the field card from 1956.
Yes, yeah. And I guess testimony that their intention is just to perform some interior renovations to that rear cottage. And we can say that they, intend to use it for visiting family, even if that's not a condition.
Regarding the Board of Health's concern, there's no anticipated increase of flow with the septic?
As long as no increase, right?
No increase, right.
Okay.
And testimony had it that they were not anticipating that. Anything else for findings?
I think that's it.
Conditions?
You're not building anything.
Not really.
No, so,
Well, yeah, I mean, consistent with what they've represented to us, I don't know.
Well, I
if
think
there's
the only
anything-
condition should be that there is no increase in the count of
Number of
bedrooms on the
bedrooms.
property based on the cesspools.
so then we should have a finding of how many beds are on the property then, for the condition?
No, I'm just going against the Board of Health's regulations. There was
Okay.
no testimony, and you
Mhm.
didn't ask, and the hearing's closed.
Mm-hmm.
So just that there be no increase in the number of bedrooms on subject property based on the Board of Health referral.
Fair enough. All right, so I think that does it. The motion was made by Paul and second by Ed. All those in favor?
Aye.
Aye.
Aye. Congratulations.
You can contact the office and we'll let you know what the process is from here on, okay? Mhm.
Okay, and the last application for the night, it's a continuation. Application 5-18, T-Ticket Car Wash, 187 T-Ticket Highway.
Excuse me, would you please state the members that are sitting on this?
Sitting on this is myself, Kim, Ed, Paul, and Bob.
Thank you.
Thank you.
There's more of us on it?
Five.
Oh, so everyone's on it? Oh, no, Bob's on it, I understand. Well,
All right, and for the applicant?
Good evening, Mr. Chair, and members of the board. For the record, my name is Kevin Clower. I'm an attorney with Ahmet Clower Law Firm here in Falmouth, and I represent Clinton Kendall, the manager of the T-Ticket Car Wash LLC. It's been a little bit of time since our last hearing, so I wanted to begin by reviewing some of the pertinent information about the property and about our application. Then I'd like to review the changes that have been made and the information that we submitted. As you know, we did submit a special permit application for the property at 187 T-Ticket Highway, which is located on Route 28 in East Falmouth, nearby the New Cumberland Farms and T-Ticket Park. It's on a lot of 24,200 square feet, and it's entirely in and surrounded by the B2 zoning district. Presently, the property and structure are non-conforming. The side yard setback is presently 9.1 feet, where 10 feet is required, and the lot coverage by structures, paving, and parking is 73.6%, where 70% is allowed by right. The existing structure is in poor condition and has hosted a number of uses over the years. Most recently, it was Tina's Ice Cream. Previously, it was a Quiznos, it was a Honeydew Donuts, it was KFC, I believe, and at one point, this board actually did issue a special permit for that structure to be raised and rebuilt as a Jiffy Lube, though that was never exercised. The applicant has proposed to raise the non-conforming structure and to replace it with a newly constructed car wash. Following comments made by the board and the public at our last hearings, we've made substantial changes to the plan, both since the initial application and since the last hearing. This has resulted in what we believe are considerable improvements. The proposed structure is now entirely conforming, as will lot coverage by structures, paving, and parking. We've eliminated both of the existing nonconformities. We believe we've also improved the traffic flow onto and off of the site and around the building, and we've addressed the noise concerns and the aesthetics of the site. I'd like to recap those specific changes. The building itself is reduced by 10 feet. This has a number of effects. It increased the setback from the street from 58 feet to 68 feet. It increased the setback from the road layout itself from 65 feet to 75 feet, and it allows for better traffic flow both onto and off of the site. The orientation of the building has pivoted And this was done by pivoting, keeping the southeast corner static and moving the northwest corner 6 feet to the north. This was done in conjunction with a southerly shift of the curb cut. The result of this is a better alignment of the tunnel exit with the exit lanes for the property. This is seeking to address the traffic flow concerns that were raised by the board. I think it's important to note that the engineering department and the planning board have reviewed the plan and had no issue with the site layout and traffic design. The parking itself was originally proposed at 12 spots. That was reduced to 11 at our last hearing, and it's since been reduced to 9. That was done by eliminating 2 of the proposed vacuums, as well as the parallel spots that were located on the northerly side of the property. This was done to address some of the noise and congestion concerns that were raised, as well as to improve the green space. Previously, we submitted a determination by Rod Palmer, the building commissioner, that the 2 parking spots that were shown in conjunction with the vacuum stalls are sufficient to address the parking on this site. All these changes contributed to the reduction by structures, paving, and parking to 69.9%, which is below the 70% allowed by right, thereby eliminating that existing nonconformity. There were some concerns regarding noise, both aired by the public and by the board. We did have a noise study completed, which was submitted to the board, and that showed that even without noise mitigation, there would be a sound increase over only a very small portion of the lot to the north. However, with the installation of a 2-meter fence, which the applicant has already expressed a willingness and an intent to do, no area outside of the site would be impacted by the noise generated on it. We did submit an updated landscaping plan showing a significant number of trees along both the southern and northern edges of the property. There was a submission made today by the 300 committee that Ms. Boudreau forwarded to us, wherein they indicated that they were satisfied with the fence and asked that there be some plantings of trees along the northerly lot line, which we're happy to do, as we intended to do it regardless. Mr. Kendall did meet with the 300 committee. I don't want to speak for him, as I was not there, but he did seek to meet with them to address their concerns, and I believe it went well. Members of our team did meet with Amy Lowell to discuss the water usage and the reclamation system, including the oil water separator. That information was included in my letter to the board submitted last week, and to my knowledge, Ms. Lowell's questions and concerns have been addressed. We did submit 10 letters of support this morning from various members of the community. In sum, as I've mentioned, this is a significant improvement to the site. We're replacing what's a dilapidated, non-conforming structure with an entirely conforming, attractive, energy-conscious, well-designed building. The existing nonconformities have been eliminated. There's no new nonconformities. The building itself will be only 12% of lot coverage, well below the 20% allowed by right. This proposal is allowable as a special permit use in this business zone. The lot and the proposed structure are appropriate and compatible with the use in the surrounding area, all of which are similarly zoned. The beneficial effects of this, the elimination of those nonconformities, the improvement to the visual character by the addition of the attractive, well-designed building, fits with the zoning and the nearby properties. These beneficial effects far outweigh any potential adverse effects. Further, we believe we've addressed the expressed concerns of the board by making appropriate changes to the plan, as well as providing pertinent information to allay those fears. I believe that Mr. Kendall would like to take a moment to address the board, after which I'd be glad to answer any questions that you may have. I believe that we've provided you with the appropriate information and appropriate changes to the plan, and would ask that you grant the special permit. Thank you for your time.
Hi, my name is Clint Kendall. I'm the owner of the proposed car wash, and I just wanted to take this opportunity to introduce myself so you could see the person behind the business, and also just give you my 2 cents on why I thought this was a good opportunity and a good way to add value to the town. Before I get into that, though, I did want to thank you all for your time. This is my first time going through a process like this. I know you're all volunteers, and I'm impressed with the work you do. I know you're doing it because you want to make the town better. And I do want to say, I honestly believe that this process has been educational for me and our team, and it has made the plan better. Everything from the lot coverage to the traffic flow to the noise measurement and mitigation has made this a stronger plan than I think when we started. So I really appreciate everyone's input, and that also goes for members of the 300 committee and other members of the town who've come to give their input as well. And making Falmouth a better place is my goal here too, and I think this business can really do that. And while there are some perceived or potential negatives with traffic or noise, I think we've addressed those, and I wanted to take a minute to just focus on what I think are some of the positive aspects of the business. First is the maybe obvious one that I think Falmouth could really use, high-quality, centrally located car wash. There isn't one in town, which is pretty remarkable for a town of this size. And I think it would be very valued by the community, and at least the letters of support that we've submitted, I think support that as well. I've been a Falmouth homeowner for about 7 years, and originally got this idea just after being frustrated myself and not having a good place to go to wash my car, and eventually decided, well, maybe I'll do something about that, and that's what got me to this point. And second, once I started down this path, I didn't want to just build any car wash. I do live here. It's my reputation, and I wanted to build a really nice car wash. And as you can see in the graphics, like this is going to be a really beautiful Cape-style building that'll fit in well with the town, which the planning board has approved. Your typical car wash is a cinder block box because that's the cheapest way to build a car wash, but that's certainly not the aesthetic that we're going for here in any way. The third thing is I want it to be environmentally friendly. That's another key thing of what makes Falmouth great, and that's both due to the efforts of the town and also organizations like the 300 Committee. And so what we've done to make this as environmentally friendly as possible is, it's not in this graphic, but the other side of the building, the south-facing roof will be covered with solar panels, and that'll generate the bulk of the electricity to run the wash. And the second key element, which we talked about at the last hearing, was the water recycling and reclamation system, which recycles 75% of the water. So between the electricity use and the water use are really being minimized to minimize the footprint of the business. And I should also add that just getting your car washed at a commercial car wash, especially this one, but even a regular one, versus washing your car in your driveway, it's much more environmentally friendly to do it in a commercial wash versus using excess water and then having untreated soapy water run into storm drains. So it's environmentally friendly, in that respect as well. Fourth is a locally owned and operated business. It'll contribute to the community from an economic standpoint of view, both in terms of tax revenue, full-time jobs, and charitable partnerships. And as Kevin pointed out, I think this is especially relevant when you compare it to what this lot is now and has been for several years, which is a vacant eyesore and the site of several failed quick service restaurants concepts before that. So I think this business use really fits the neighborhood, fits the lot, and will be a great addition to the town. As far as myself, I won't tell you my whole life story or resume, but I'm an experienced business person, and I feel very confident that this is a good business plan. I'm even more confident that I'll be a good neighbor and partner to the park, to other abutters, to the town as a whole. So I'd appreciate your support. And as Kevin mentioned, I have met with Virginia and a couple other members of the 300 Committee leadership to talk about their concerns, as it is adjacent to a park. We talked about the noise study we were doing at the time and the mitigation steps we've taken there. And I think, as Kevin outlined, the steps we've addressed have addressed that. But just to go a step further, I offered to them to put additional plantings. I mean, we'll plant what we can on the car wash side of the lot, but to do additional plantings on the park side, if they desire, to add additional both visual and acoustic screening. And I think they'd like to take me up on that. So we can flesh that out offline. But so again, we'll do whatever we can to make it work from the park's point of view, as well as the other logistical concerns. So that's all I had, and I'm happy to help Kevin answer any questions about either the business or my background, if you like. So hopefully you can support it. Thank you.
Thank you. And I think we'll just turn it to board questions. Bob, do you have any questions?
No, I guess my main concern is what I had before, mainly with the traffic flow and the impediment. So on the right-hand side of the entrance, you've expanded that little island. Yeah, right there.
Yep.
For landscaping.
So,
And that's decreased the width of that queue area, staging area?
It did reduce the queue area a slight amount. What we wanted to do was really to orient this so that the tunnel exit was a straight line from the midpoint of the exit area. By increasing this slightly, we were able to bring our lot coverage to an appropriate point, eliminating those nonconformities. We believe that the queue area, in talking with our advisors, that the queue area is still more than sufficient to meet the needs that we would have. We really didn't lose much in the way of queuing space by doing that.
How many vehicles right now fit in that queuing space?
In talking with the engineer, I believe it's still 14 that would fit in this queue, and that's just in this space here, between, because you'd have cars potentially queuing.
I visited the site on multiple occasions and tried to do different times of the day to see if there's traffic differences, and I've had the same issue every time I've gone to the site, that it's a very nice design, the building, but for what you are trying to fit on this particular site, I cannot see where traffic will not back up towards the street. And you're also still getting in the situation where you're having vehicles enter and cross paths.
So
have you done anything to alleviate that at all? Or?
Well, what we tried to do, the last hearing, you would express your concern that people were coming out and would have to veer slightly to the right in order to come out to the midpoint. So by changing the orientation of the building, we made it so that it was a straight shot coming out. You'll have cars coming in. You will have the occasional car going left into the vacuum area. I think the majority of people will come in and use the vacuum, and then if they choose to vacuum, will turn into the vacuum area. What we've done to address your concern, that was what we had picked up from the hearing, was reorienting the building in order to align the exit of the tunnel with the exit of the site, because that was the concern you had routinely expressed of cars coming out and having to veer slightly to the right towards the exit. In terms of cars lining up here, in working with the advisors who design car washes for a living and work with these things, they felt that the queuing area was going to be more than sufficient in order to address this. I might be mistaken, but I did not think that there was a significant concern expressed at the past hearings of cars backing up on towards 28, because we felt that the queuing area was sufficient to address that.
That's all I have right now.
Well, I have no questions.
And the drawings, the recent drawings you sent, I laid out how many cars could fit in the queue. It's more like 8 or 9.
Well, you have to remember that you have cars queuing here, but you'll also have cars queuing potentially in this area here. So if you were to max it out, we believe it's about 14 cars, where previously it was somewhere between 18 and 20.
20 was definitely not right.
I can only go with what I'm told on some levels.
Yes.
But Kevin is correct that you'll have, on a busy day, you're going to have cars queuing up at the pay stations, but then also lining up to enter the wash.
And I'm also concerned about making a left turn coming out. That is a busy street in that area with all traffic.
So I know that at one point it was mentioned about the potential of a right turn only. That was mentioned at one of the hearings. In looking at other properties, I'm looking at other permits that have been issued. I'm not aware of any special permit that's been issued on T-Ticket Highway or Route 28 that restricts the left-hand turn only. Kim's shaking her head, perhaps I'm mistaken, but I'm not aware of any.
Subway has a right turn only.
Okay, I wasn't aware of that.
Yeah.
But that's the only one I'm aware of, because I know.
CVS as well.
But that has two. That has an exit onto Worcester Court and an exit onto.
I'm just saying, on 28,
yeah.
It's right turn only.
However, McDonald's doesn't, Burger King doesn't, Town Fair Tire doesn't, a number of projects. Cumberland Farms doesn't. So the Dunkin' Donuts on Sandwich Road, at the corner of Sandwich Road and T-Ticket Highway doesn't.
Not the same.
Would you be opposed to a right-hand turn only?
Well, it's been expressed to us by some of the abutters that they'd be very opposed to it.
The abutters would be opposed to a right-hand turn. Oh, that's what you said, correct?
We're asking questions right now.
Yeah. Clarification.
I don't want to put words in anyone's mouth, but am I correct in saying that, Mr. Vizzoco?
We're dead against the right turn only.
If there's going to be any testimony, you'd have to come up, and
So,
we're not at that point.
Mr. Oh, sorry. Mr. Fazzoco owns the property, the plaza across the street, and his concern, it was discussed at the last hearing outside, was that if cars were to be forced to take a right-hand turn, that they'd use his plaza to turn around and go the other direction. So he was very opposed to that, and that was his concern, and we expressed to him that that was not our intent. At that point, it had only been mentioned once in passing at one of the hearings, so I didn't think it was something that the board was overly concerned or intent upon.
Let's open it up.
Yeah, so you had just said, when you were giving your spiel there, your presentation, you said that the planning board and engineering have reviewed. Are you talking about the new plan too?
So they had reviewed the old plans that the board was
Yeah.
concerned with. We did not resubmit the plan with the slight orientation shift. I don't see how that would affect, I mean, if anything, we think it, you know, we think it improves because it was done to address that specific concern. But they had, you know, when we went to the planning board with the engineering referrals, there was really no issues with this plan whatsoever. And we went through the site plan review process very quickly without much in the way of pushback because they were very happy with the plan and the design.
There was a comment by staff engineer regarding the 30-foot entrance, the 30-foot span, that they felt that making that 3 10-foot wide lanes was too tight. Was that ever addressed?
I'm not familiar with that specific comment.
Do we have it in the file?
Yeah, Scott Schlichter had made a comment.
Okay, so that was my only question.
To follow up on that, do I remember something about a curb cut and that being a state highway? Was there an issue with Mass DOT regarding
So
that,
we're
Kevin?
operating within the existing curb cut.
Mhm.
Previously, it had been located a little bit more to the north, still essentially within the same curb cut. We've since moved it back south within the same window. You can see the 30-foot wide opening is at this point here. You can see some of the existing curb shown on the landscape plan that you have. But we've maintained the same 30-foot wide opening. The shift really is in these areas here.
And regarding the proposal of trees being installed on the T-Ticket Park side, two things. Can you show us where on the map they would be put, and what sort of trees are you anticipating, if you've gotten that far with the 300 committee yet?
I would anticipate would be speaking about this side of the fence up here. I think that Mr. Kendall would be happy to basically put in whatever kind of trees they wanted within reason.
Specifics of that, yeah, but that's the basic idea too, in the area where Kevin pointed out.
And just to refresh my memory, because it has been a while since we've seen this project, the back portion of your lot abutting the 300 committee, did testimony have it previously that there was already
Very heavily
vegetated?
Yeah, and they said, you know, don't focus your efforts on this area here because they had enough coverage there, which is why we're focused much more on the southerly and northerly side. Ms. Beelan had indicated previously that she was concerned about the southerly side, so we have increased the number of trees that direction, as well as maintaining trees on the northerly side.
Okay.
And all of this would be in conjunction with a 6-foot fence surrounding the property.
All right, thank you. Jerry, any questions?
No, I think I've missed at least one hearing, but I think you've made substantial improvements in the fact that
All
you're
right.
working with
Questions only, Jerry?
Okay. I think he has made substantial improvements. I mean, the project has had substantial improvements.
Okay.
And working with the 300 committee. I note that the traffic
Well, we're not quite to board discussion yet. So you-
concerns, what are we at?
Just questions for the
Questions?
applicant.
Questions for the applicant?
Mhm.
I have no questions. I think that,
All right, so we can
yes.
move along? All right. Any other questions from the board, or Sari?
No, I have nothing.
Okay. All right, we will turn it to questions from the public. Any questions, comments, concerns? Ms. Viella?
Thank you, Mr. Chairman. Virginia Valiela. I'm on the board of the 300 Committee, and I want to thank the applicant for the efforts that he is making. We still have a number of questions and concerns, and I'm going to just pick up on the last one, which was Mr. Clower's comment about a 6-foot fence, but what was modeled was a 2-meter fence, which is nearly 7 feet. And it was a 2-meter fence that was supposed to stop all of the sound going to the park. So I want that discrepancy to be clearly stated. And if their statement about not having any noise impact the park, then it needs to be a 2-meter fence as modeled. I would also note for the modeling, they modeled it with 3 vacuums, but there are 6 vacuums. And so it seems to me they should at least have modeled the worst case with the 6 vacuums all operating. They also state that the model, and this is the modeler in his report, assumed that the vacuums would be 4 feet high. I don't know whether that assumption is correct, and we have not had a lot of specifics about the particular kind of vacuum, except there was some assurance that it was a more modern, quieter one, but I think we need to be specific about what the vacuum is, and is the noise actually emanating at 4 feet, or is it at a different level? The committee, the 300 committee, had asked before and have not heard a response on. Sound not only goes out, it goes in 360 degrees, and so the wall of the building is immediately behind these vacuums. And so we'd ask about whether there would be any sort of sound absorption that would be installed on the wall of the building, and we have not heard any comment on that. I will just ask one more question, which they can answer the next time they speak here. Where do you pay for the vacuum? Is it at the site or is it at the kiosk? That might have an effect on some other questions we have. Okay. We had several other questions. The cupolas, the height of this total structure, do the cupolas themselves, there are 3 of them shown there, do they actually have a function, or is it purely an architect's sense of architecture? It would seem to us, if they have no function, that the site would nestle more into the landscape if the cupolas were not present. We believe that this is a very tight site. It's 24,000 square feet, as was mentioned. We went online to the company that has been at some of the previous hearings that would be providing the equipment, and looked at their videos, their training videos for setting up car washes, and they recommend 1.5 acres, if not more. So we really feel that, again, that a great effort is being made. It's tasteful, but to put something into a very small space. We believe that the cross-traffic is going to create backups onto this very busy, congested highway, and that you just are not going to be able to get around that. And so that this will have backups just the way the one in East Falmouth does as well. I do think that the assertion that there are room for 10 cars to queue up, what really needs to happen is that you need to go out there and flag it and actually show how many cars can fit there. A lot of vehicles now are vans and 151 F-150s, trucks, and so on, so they're large vehicles. And so we think that the backup is going to happen. If this does get approved, we believe we can work with Mr. Kendall on approving the landscaping on the north side. The plywood that was referenced in the acoustical study hasn't been confirmed that the fence will be plywood. But in any case, there's been no discussion whether it's going to run the full length of the north property line or whether it's going to stop where it currently stops now. There's a chain link fence for the first maybe 50 feet, and then the stockade fence starts. So we need a definitive plan as to what the fence on the north side would look like. Thank you very much.
Thank you, Ms. Fiala. And you were speaking in your capacity as a member of the 300 Committee?
I'm a member of the, yes, and with me is the vice, the vice president of the board at this time, but she was not at the previous hearing.
Thank you. Any other members of the public? Yes, sir.
Hi, my name is Bill Frizzoco. I'm one of the owners of Driftwood Plaza. And, I'm speaking for my family. And we've looked at this. I commend you and your presentation. But the more we look at this, the more I look at this, I think it's going to be problematic for Driftwood Plaza. I definitely want to go on record saying that a right turn only would diminish the value of our property, would funnel all the cars going right that want to go left through our property as a bypass. I mean, it's the path of least resistance. I don't think anyone here is going to say that isn't going to happen, because I do it all the time. If I can get to a place quickest, I'm using it. So I don't want Driftwood Plaza to become a bypass. My problem is you've got one entrance and 3 different ingresses and egresses in this one exit. So even if you do allow a left-hand turn, I gotta tell you, I have a feeling cars are gonna go right because it's the only way they're gonna go, especially in heavy traffic. Then go into Driftwood Plaza, swing around and come out. It's gonna be a mess. You've got a stack with no bailout. I mean, I have never seen a drive-through with no bailout. I have been to East Falmouth on a Sunday morning. The cars stacked to Route 28. I don't see why this is gonna be any different. And their building in East Falmouth is set up right, where the ingress and the egress are equal. This is a disaster ready to happen. I mean, you're creating a huge hotspot, which is directly across the street from our curb cut at Driftwood Plaza. And, I don't see how, it's gonna, I mean, especially now, if you go out there and see the cars stacked, especially when the light at Mara Vista Extension's on, it's bumper to bumper. So, I mean, I believe we have rights as a property owner. I think a right-hand turn is an absolute no. I still think the way this is set up, it's still gonna be problematic for us. I hope you take that all into consideration. I mean, you've got vacuum cleaners on one side, you've got cars going in and out. On one side of the building, you don't have a stack on the other, your stack doesn't have a bailout. So, I don't see how it's gonna work. You got a small lot, and you got a lot going on in one lot. So, that's what we got.
Okay, thank you.
That's my position. I want to be on record, and I think I've done that.
That you are. Thank you. Any other questions, comments, concerns from the public? Yes, sir.
My name is Mort Cohen. I'm resident of Falmouth, Sippowisset Road. I just had surgery in December for heart. I went to wash my car this weekend for the first time, and I couldn't do it. I won't take it down to East Falmouth because I can't handle the equipment there. I'm very much in favor of this proposal. I've heard a lot today. I think there's nothing that can't be resolved. But I really think with the town and the senior population here, I'm of the generation, and I know a lot of my friends are of the generation, that they believe if you take care of your automobile mechanically and physically, it will take care of you. I have a 17-year-old vehicle and a 9-year-old vehicle that's been washed, that's been maintained, and that's my thought. A lot of my friends are the same way. So I'm very much in favor of this proposal, and I would hope that the board respectfully will approve it. Thank you.
Thank you. Anyone else out there wish to make any comments? All right. Attorney Clara, would you like to address some of the issues that were brought up?
I'd be happy to. As to the fence, the applicant is happy to essentially surround the property on the northerly, easterly, and southerly side, not necessarily up to the curb, only because of sight lines. We need to make sure that's appropriately set back to not impede sight lines, but to within a reasonable distance from the curb, the lot line, in order to address that. As to Mrs. Valiello's comment regarding the vacuums, the sound engineer, the sound consultant, was aware of, actually at that point it was 8 vacuums, which have since been reduced, and he said based on his experience modeling car washes, 3 would be what you would typically use in order to model the sound. That 8 has since been reduced to 6. And so in that situation, I typically defer to the person who has the expertise in the area. So when he said, let's model 3, I said, okay.
Yeah, I'm sorry if I could add to that. His thinking was not just, okay, there's 6 spots and only 3 is going to have a car in them.
Please use the microphone.
Oh, I'm sorry.
Thank you.
I was saying that not that necessarily only 3 cars will be in spots at a given time, but that even if there's more cars in the spots, that the motors and the vacuums will, they're not running 100% of the time. You put the money in, and but meanwhile you're opening the doors, you're cleaning out the cups and junk of your car, you're taking out the floor mats, whatever, so the motor itself isn't running all the time. So he thought kind of 3 was that fair midpoint to model it on, so that's why we did it that way.
As to the height of the vacuums, I do believe we're actually lower than 4 feet.
Sorry, this is Ron.
My name is Ron Campagna. I own the company that installs the car wash equipment. I believe it was my website she was on. And I've put car washes on this size lot and a lot smaller. We did the Hyannis car wash for police. We did Hyannis Toyota, small lot. We did Sandwich car wash 28 years ago on Route 130. We service well over 1,000 car wash. I started my business 50 years ago this year, and I'm still working every day. But as you can see, I'm here. But I see this as very workable. I mean, no matter what business you put on this, you're going to have to take a left-hand turn or right-hand turn. You normally have more trips in a bank than you would in a car wash. And then this is the vacuum. It's 4 feet high, and the motors are on the top. So this vacuum makes a noise like a rushing sound. It's not a noise that would be irritable. There are noises that are irritable, but when you hear a vacuum cleaner at home that you're pushing along, it's got a whole different sound. You won't even hear it on the lot line. I'm telling you, you just won't. The car wash was designed to wash cars rapidly. So if they were lined up on those super busy days, and how many do you have? You get a handful. Some of them, a snow, icy day, cold, winter, cars are full of salt. Yeah, you're gonna have cars in there, but summer days, you're not gonna be that busy. It's not gonna be car after car after car. I hope it is for his sake. He's looking at me like I wanna kill you, but we hope it will be. But this car wash will be rated so that it could wash, if necessary, 120 cars an hour. So if they're lined up, he just has to go to a dial and speed up the wash. The equipment in there will wash that many cars. We're not going to. We're going to have it at 60 car an hour speed, but I can speed it up if we see that they're starting to back up on the entrance line. On the exit line, we're going to have a situation where there'll be an anti-collision system. So if there's a backup, we're going to have the conveyor stop. If the car in front of it stops, it'll know the car stops. It'll be on a sensing pad. The queue, you'll have 2 cars coming in at a time. They'll pay at the gate, and they will pay at the vacuum, ma'am. They pay at the vacuum, yeah. They can pay with credit card, they can pay with cash. I'm sorry.
Through the hands of the board.
Oh, okay. They can pay with credit card, they can pay with cash. But the motors are on the top. We're having a special top made that's insulated so that it's going to get rid of any sound that might go off the property.
Can I add something to that, Ron?
Sure.
To add something that Ron said, but to specifically address the comparison of the East Falmouth car wash and, you know, the backups that it causes. As Ron said, the big difference between this car wash and the East Falmouth car wash is the rate of throughput. So if you can get cars through the wash quicker, they're coming in your queue, they're going through the wash, they're getting out, you're taking them off the street, putting them back on the street faster. The East Falmouth car wash, I don't know if you guys have ever been there, but you pull up, you get out of your car, you wait while it goes through, you get back into your car. It's not a fast system. And so that obviously creates a bottleneck and a backlog, which can spill out onto the street. So I don't think that's a fair comparison to what we're going to be looking at here. So, thanks.
Continuing on with some of the other comments. As to the cupola, I think that was designed that way in order to reflect a lot of what the planning board has been looking for in other similar projects, Town Fair Tires, CVS. That's the design they've been looking for, and that's what was encouraged to us by the planning board, which is why we ended up on that design. They don't serve a functional purpose in terms of housing any machinery or equipment, but that was, in going through the site plan review process, something that was encouraged to us, and what the planning board has been looking for. I believe Mr. Campagna addressed some of the cross-traffic concerns that were raised. As to the bailout, the gates can be raised manually. In the event of someone needing to leave, it would be addressed by, it is staffed. It is not an automated car wash. It is staffed by 2 to 3 workers at any given time. So there are people on site to address these situations when they do arise. It is not intended that they arise on a regular basis, obviously, but in the event something were to occur, people would be able to get out. They wouldn't be stuck in line because there are employees on site. And as to the traffic buildup, I think Mr. Campagna addressed it, but I would just go back to that this has been done in conjunction with designers who have been doing car washes for 50 years, with site plan engineers, with the civil engineers, and with the town's engineering department. And this particular board and the comments here have been, there have been some traffic concerns, but that has not been raised at any other level to this point. It's not to say it's not a fair question, but we believe that it's been addressed in an appropriate manner, that it's not problematic on the site.
Could you address the height of the fence, I think?
That's my being bad with metric.
But you're going to change the fence?
We'd be happy to do a 2-meter fence, yes.
And I have a question for Attorney Clower. Attorney Clower, with all the experts that have weighed in on this, our planning board, the engineers, the people that design these car washes, how is it that they missed all these hazards? That's a joke.
I understand, and I was going to say, I think that a lot of these are perhaps perceived hazards.
Yeah.
But not actual hazards that will bear out.
Okay. It's a rhetorical question.
I can't leave anything unanswered.
I have a question for.
It's a bad habit.
Just a question, but you comment on the bailout lane. So if somebody did have to get out and you raised the gate to push them through, wouldn't there be cars lined up on the other side of the gate trying to get into the car wash?
I mean, so, yes, is the short answer. However, let's take a medical emergency, right? Someone's here, they need to leave, they get a call, someone's in the emergency room. It will be made to work because people will be able to get out. You're not going to leave someone trapped in there while they're clamoring to get out. By being able to lift them on a manual basis, and having it staffed, I think that contingency can be addressed appropriately. I haven't gone around and checked every drive-through in town by any stretch of the imagination, so I can't say whether or not there are any or aren't any that don't have bailouts. I know of some that do. I haven't paid enough attention, I suppose, to really thoroughly vet that comment.
Any other
I'm
questions?
sorry, I missed the point. You did answer Virginia Valley Alice issue about the fence being on the north, the south, and the east.
Yes.
What is the height and material?
We're happy to go to 2 meter, and two meter.
2 meters?
2 meter.
Thank you.
3's really high. As to the, I would rely on the sound consultant to tell us the appropriate materials. I think.
Okay. That's
I-
fine.
I-
That's all I wanted to know was the
I
height.
was just gonna add on the fence that, when I spoke with the sound engineer, the point he was trying to get across was a solid, wood fence, as opposed to, say, a vinyl, plastic fence, or anything with slots that, that's something that wouldn't absorb the sound. So I think as long as it's like a board of some kind, that satisfies it from the sound point of view.
Thank you.
Any other questions from the board?
I have a question.
Yes, Jerry.
It was your testimony from a sound consultant that it could hardly be heard or would not be heard at the property line due to all the mitigation.
It would be within the appropriate levels, is what the sound consultant said.
What are those appropriate levels?
So the sound consultant does a study which measures the ambient noise over a 3-day period and averages it out. And they measure what's called the L90, which is 90% of the average noise. And the measurement is 10 decibels over that L90. And he did kind of a spray chart, which shows the sound emanation coming out both in this direction and this direction. And by installing the mitigation, there's no impact outside of the site. Versus without sound mitigation, there's only very little impact over about this portion of the site.
Okay, my next point, and unless the gentleman in the back is a sound engineer, my professional experience is that you measure 3 and you're going to have 6 vacuums. A doubling of the noise source only increases the noise by 2 to 3 decibels. I used to be able to do that calculation, but I can't. That's it's an observation, okay? It's clarification to members of the public that were concerned about the sound, and it was a very legitimate question. It was my professional opinion, and I don't know if they have any, that this should not have an adverse impact on sound because of 3 machines being measured due to the physics of sound. I don't know if you can address that or not.
I agree.
Okay.
All right. No more board questions? If it's, we really need to move on. I mean, you addressed very valid concerns that and they've been addressed by.
That needs to be.
Can we just have some board, because I know Jerry started some discussion.
Right.
And so I just want to hop on. I do want to say, Jerry, I don't mean any offense by what I'm about to say, but I don't think that you're a noise consultant.
I am a professional engineer. I have studied this. Okay. I will assert, and it came up with the wind turbines, that this is a generally acceptable standard, and I don't think we've ever questioned a board's member's professional opinion. I don't question your legal opinion. I may not agree with it.
I'm not here in my legal capacity.
But you have expressed legal opinions. I'm expressing.
So have you. Anytime that you apply the zoning bylaw, you're expressing a legal opinion.
Okay, let's back up. My professional experience as a registered professional engineer who have studied this, and I taught it at the undergraduate level, and it was confirmed during the wind turbine studies, that the doubling of sound only increases.
We're getting away from the issue.
Well, no, she addressed a personal issue against me.
I just asked you if you were a noise consultant.
I said I'm a professional engineer and I can speak.
Do you have experience in acoustics?
Let's
Yes.
move on.
Yes.
Okay, that's all you could have
Okay,
said.
Those
thank you.
comments should be for the board, directed towards the board during discussion. You're not here to address the public and explain things. It's for a board discussion.
Well, I'm expressing to the board
let's move
my
on,
professional opinion, not a personal opinion. A professional opinion as a professional engineer.
Okay.
Chairman Hurry, can we move on?
Yes, so I just wanted to bring up a couple of points. First, David Coe Consulting, who did the noise engineer, I've worked with him in my professional capacity. I think he's a well-qualified noise consultant. And so I certainly credit the report that he gave. I appreciate everything that the applicant has done in terms of the design, in terms of meeting with the neighbor, in terms of, trying to address concerns. With that said, there were a couple comments from the members of the public right now that are, I think, certainly capture how I'm feeling. The fact that, I think, Virginia, you mentioned it was tasteful, they've made a great effort, but they're trying to fit something into a tight space that doesn't fit. And then also the concerns regarding the 3 lanes coming out of the one curb cut, this stack with no bailout, that's probably my greatest concern, is the lack of ability to get around if you don't intend to go to the car wash. I'm just looking at our criteria, 24216. I know from a personal level, I couldn't find that the site's adequate in terms of size for the proposed use. I think that this is a tight space for this, and I certainly agree with that in terms of suitability of the site for the proposed use. I think it's a nice project. I think what you've done is really nice. I think you've presented information from the noise consultant, traffic I'm not really too concerned about in terms of adding traffic. I know it's a heavily traveled way. I don't think you're going to add that many trips. But I think there's conflict points on the site. I'm certainly not an engineer, I'm not an expert, but from a practical standpoint, I think the site's too tight. So that's where I'm coming out. And so that's why I think you've done a lot, but I don't necessarily think that there's anything more that can be done because the site is what the site is. Those are my thoughts to the board.
Anyone else?
Well, I'm under the similar impression. I don't think it meets 240, 216. I don't think it meets A, B, or C. Specifically C, the impact on traffic and safety. I do think there's going to be a backup into that main road. It is very difficult getting out of that entry. And just by the nature of this business, it is a car wash. It's there just to attract vehicles. So you're trying to get as many vehicles on the site as you can as possible. You can speed up the car wash, but they all still have to get out on that main road. And I think there's going to be a backup issue there. I don't like the idea that there's no bailout lane. I think there needs to be a better staging area. It's a very nice design of the building. It's a nice business model. Again, I just don't think it works on that site.
I love the project, but you know, I see which way the wind's blowing.
I think the same way, and I think, you know, if the lot was another 20,000 square feet, it'd be probably perfect. But I think it's just too much on a small lot. And I'm concerned about the safety out on the road, getting out there and you put 120 cars in an hour. It's an awful lot of cars.
Well, I want to comment on that, Mr. Van Kuren, which is not to say that's what the flow through the site would be. That's what the rate of car wash would be. So that's not to say 120 cars are coming in and out of the site per hour. The traffic calculations estimate 14 cars an hour. So.
Yeah, that's more reasonable.
But you don't wash at that rate.
No. I just think it's too much on a small lot.
All right, and I guess I can chime in now. I know the applicant did work with the neighbors, especially regarding trees on their property, which is great. They did increase green space on the proposed lot, which we did ask for. Fencing and all that, the noise study provided, I think it was good. I know the board did have many concerns about the traffic going on the property around it and exiting. I think that everything was actually properly addressed. Do have some concerns with turning out on the left lane, but there's plenty of businesses along that stretch of road which you do have to fight 28 to go on. So this board knows, and members of the public also know, that Kim's an attorney. I'm an attorney as well. We're going to agree to disagree on this one, although I do not practice property law anymore, but that's okay. Doing something else now. So I would be in favor of this project.
I'd like to speak, even though I'm a non-voting member. Sure. I mean, I guess I agree that I think this is a suitable use, if not an improvement, to the site. Suitability of the site, adequacy of the site, you know, that's a somewhat judgmental. I think the impact on traffic is simply, if the traffic is impacted, people will not go there, or they'll come back a second time or a third time. I don't think it's in this board's purview to fix the traffic problems that are on 28, that every project that comes before us has traffic, and I think, yes, it's going to have an adverse impact of traffic, but not to the level of some of my colleagues seem to think would happen. But I also can count. And I'm not a voting member.
And I just have one more comment. I think that it's a lot better than a 4-story, 65-unit apartment building. That's another joke. No one's laughing.
No, no.
It's a little late, Paul.
No.
You just gave me an idea.
All right.
All right, so
before-
Attorney Clowery, I think you see, you're reading the tea
where we are right
leaves.
now. I guess my issue and my quandary is, I feel like we've done everything the board has asked at this point. We've addressed the things the board has asked, and yet, you know, we're being told no. So, you know, it seems like the board's either not gonna approve a car wash here, or they are gonna approve a car wash here. And I'm not gonna force that question right now. You know, I can speak with my client. I'm not sure what further changes can be made to the plan at this point, to be quite frank. But given the results of a denial, I'd rather that not be the case, and I don't really want to withdraw without having a chance to discuss this with the engineer, with the designer, and my client. I understand that we've been at this for a while, but I'd ask for a chance to continue it, and if we cannot come up with any suitable arrangements, we will withdraw to next year.
Personally, I think that's a fair request. How does everyone else feel?
Yeah, I mean, I'm all for it.
My only hesitation, I certainly, is just that the site is what the site is. I think we've been at this for months, as you point out, Attorney Clower. I think the limitation that I'm finding, I don't want to speak for Bob, but is that it's the site, and that's something that you can't change. So I don't know if it's helpful to push it all further. We've been at this. I think it's a nice plan.
I think the alternative is
site.
a drastic change to the building itself, which hasn't been explored because this is the model that works best. But it's probably worth the conversation.
I mean, obviously,
Well, it's just that, I mean, these are all the issues that have been brought up over and over again. I don't know anything tonight that's been different, that's been brought up.
I find that a little insulting, actually, because we've made the changes that were requested in
Yeah,
terms of changing the orientation
but
of
we,
the building.
but, no, and I know you've made changes, and I think you've made the changes that you can with the site, but, you know.
But the problem is the goalposts keep getting moved. So when you talk about the traffic not being in a straight line, when the traffic becomes in a straight line,
Yeah,
it
but Kevin,
becomes a different concern.
I brought up at first meeting about the opening, and you said, you're not gonna enlarge the opening. I brought about can you get a bailout lane? There's no bailout lane. So I understand you've done the adjustments in the building, but, you know, all due respect to us too, we have brought up these issues before. This isn't a surprise. I am surprised that site plan review didn't have any questions about traffic flow on this site.
None whatsoever.
Because even car coming in and crossing lanes, you'd think that'd even be a comment.
I'm not necessarily surprised by that.
But I just,
Because I think we've improved projects in the past, and I think this would be, as you pointed out, an improvement over what was approved for site plan approval.
And Kevin, I don't think it was the intent of anyone on this board to insult either you or the applicant.
Well, I appreciate that. My point is that I think in some ways, you know, whenever we address one thing, it's, well, yeah, but what about this? And, you know, there are only so many things we can change. And I think we've sought to address the concerns that were expressed by the board as being their pressing concerns. And now I'm being told that there's other pressing concerns, which is fine, we'll discuss it. But all I'm asking is that we have a continuance in order to have a chance to do that.
Okay, so we've heard from the applicant. What would the board like to do? Would anyone like to
Make a motion
any
to
sort of
close.
motion?
Make a motion to close the public hearing?
Do we want to close it if we're going to continue it?
I mean, whatever.
I don't know,
I
I'm
made the
asking.
motion, it doesn't have to carry.
You made a motion to close, is there a
All right,
second?
made a motion to close. Is there a second?
Let's go through the process correctly.
I'll second.
All right, motion's been Paul, second by
Now
Paul.
you can vote.
All those in favor?
Aye.
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 How many was that?
4, 5, was it 5?
It was 5?
Five.
Okay. That was your chance to change your vote, so it's closed.
All right. And how would the board like to proceed?
Well, I mean, I'm certainly not voting in favor of it based on what I said earlier. Bob, I don't know if you are, so I don't know if we want to give the applicant a chance to, if they want to withdraw. But I.
Close the hearing.
So we would have to reopen in order to give them a chance to withdraw? Okay.
That'd be fine.
That would be your preference rather than us voting?
Rather than you denying it, absolutely.
I'll hear a motion to reopen.
I will move that we reopen.
I'll
the
second
public
it.
hearing.
Okay, that's Kim, second by Ed. All those in favor?
Aye.
Aye. Attorney Clower?
So while it's open, I will ask the question, does the board have any tolerance for us doing a continuance so that we can discuss this amongst my client, the engineer, and the site, and the car wash designer?
I think that we were ready to close it. That's that's what we just did.
Anyone else?
We reopened, I think, for the purpose of
But
allowing
just during, just while we're
withdrawal.
open in discussion, I'm asking the question, because that would be our preference.
How does everyone feel?
Yeah, I mean, it doesn't bother me. I mean, I mean, I'm fine with it, but,
I think we reopen for the chance for the applicant to withdraw.
Yeah.
okay.
I do have one additional idea of a way to change this that may work. I'm not sure it'll work, but I'd like the opportunity to at least think about that before we shut it down permanently.
Okay.
But if the board's not willing to allow us continuance in order to address the issues that were raised tonight, which it sounds like they're not, I suppose we have no option but to ask for a withdrawal without prejudice.
I guess I'd like to maybe speak to the board that we've given applicants many of opportunity to come back. They know what the board is. If they come back and they don't address the concerns of the board,
So the standard is if they withdraw at this point, then they can go back to the drawing board, and
Right.
within 2 years, they would have to come back with something that's substantially different than what was proposed.
but they
tonight.
still could come
That's if
back
we deny.
if
Oh,
we
I'm sorry. If we
If,
deny.
if it gets continued with the understanding that the board's gonna have low tolerance for any minor changes, they know what the board's concerns are. What are we, another month or 2 months to possibly allow this to go forward? If the people say no, no matter what they do, it's no, then yeah, it's a no. But the board's always been, let the applicant have an opportunity to address the concerns. And now they've heard, we may disagree, they've heard nuances to what our concerns were. If the people that raise the questions may say no, therefore it goes one way or the other. But I think we are the Board of Last Appeals, or whatever it says, and I would say give them the benefit of the doubt. What's the difference between a no today and a no a month from now?
I'm not gonna pretend I've been doing this for 40 years, but I have been doing it for 6, and I've never known this board not to grant a continuance when they've expressed a desire for changes.
I don't think a continuance was requested yet. I think you discussed it. And what the board did is they went ahead and closed because of the way that the wind was blowing, so to quote somebody else. And then they reopened to give you the opportunity to withdraw.
Well, rather than
So
to
it's
be
back in
denied,
the
yes.
board's court. What do you want to do? Because we're prolonging this. Do you want to
If-
allow them to continue?
I want a car wash, so I want it to continue.
That's not the question.
I
Do you
know.
want them to continue?
Do
Or
we
do
want a
you want to
continuance
close
for
the
this?
hearing?
Or do we want to close?
I'm fine with the continuance, that's just me.
I'm willing to give them a continuance.
I'll go along with
Then,
it.
then somebody make a motion and let the vote carry through and see how it goes.
I'd like to make a motion to continue this hearing to a date certain.
All right, I will, guess I can second that. All those in favor?
Aye.
Aye. And what was the count there?
Any
I don't know.
opposed? I
Couldn't
can't hear the
tell.
vote.
What was the count?
Aye.
So how many granted and how many opposed?
You gotta take it.
Think
How
we
about
need to-
raising your hands?
I think we need to take it again.
Can you retake the vote, because I
So
can't hear.
all those in favor?
Aye.
Aye.
So 4?
3.
All those opposed?
Aye.
2.
3 to
3 to
2,
2.
motion doesn't carry. And then any other motion?
I will move, well, I don't want to move to close because I want
If,
them to have the
if,
opportunity
if
to.
we're not gonna get a continuance, we have no option but to withdraw without prejudice. So I would ask that you grant that.
Okay, so the applicant is moving to.
I'll move that we
remove without
allow
prejudice.
applicant 518 to withdraw without prejudice.
Second.
Motion is made by Kim, second by Bob. All those in favor?
Aye.
Aye. That motion carries unanimous.
Thank you.
Thank you. All right, moving on to our open meeting items. We've already covered the minutes of June 7th and June 21st. That moves us along to the second board admin approval, request for a de minimis determination on the 24.5-foot setback at 9 West Hill Road in North Falmouth. If everyone could please quietly exit the room. Those who are exiting, please.
Excuse me?
Excuse me.
Excuse me.
We are still in public meeting. If you could all please quietly exit the room. We still have agenda items.
Kevin?
Everyone? Sorry. Thank you. Not kicking you out, but if you could leave quietly, thank you.
They're requesting a de minimis determination. This house has been existing quite a while. And the setback is 24.5 feet. Where's my notes? It's an older home, and it's been existing for a while. This is one of those issues where, you know, it was created years ago. Right now, the instrumentation is a lot more sophisticated, so they're getting truer setbacks. So they're asking for a de minimis determination of 24.5, where 25 is required.
That's us to that front.
Right.
What's that front setback, 3?
For like what purpose, though? I'm
Just for the determination that it's de minimis.
that it
Because they're-
conforms, that it's so de minimis that it's not a nonconformity?
I will move that we find it de minimis.
Second.
Motion by Kim, second by Ed. All those in favor?
Aye.
Aye.
Okay. Were you asking me? They're gonna add a minute.
Oh, okay.
Thank you, sweetie.
Yeah.
Moving on, board
Is that
updates.
killing you?
Well, I know I
Right,
need to do the rules and procedures. I know I need to do that.
Do you want me to help
Since
you
I'm
at
no
all?
longer imminently leaving the board, it appears, that I will have time to do that.
Okay.
Thank you.
I would ask that we have some discussion before that, ending my leave.
Yeah, of
You might
course.
want to change the administrative review process.
So we can add that to the open meeting items?
No, I'm just
Yeah.
talking about when you redo the procedural
Oh,
rules.
right.
It is on the agenda, so I'm asking you to think about that and maybe draft part of that, Kimberly, when you draft it.
I got one other thing. The, Sheree sent out a notice, or the subject was House and Senate prepare major zoning bill, and there's of course, you know, what they're planning. And I talked to Sheree, and I thought it'd be a good thing for the Board of Selectmen to send a letter to the legislators to support this.
That's a good idea.
I think that would be a good idea.
To support the bill or oppose it?
Say again?
To support the bill?
Yes.
Doesn't the bill reduce the majority to simple majority in town meeting rather than 2/3? I mean, I'm asking
For the
Sheree.
zoning? I believe so, yes.
So it's, what MMA said is they think it could be substantially reducing the power of town meeting.
Correct.
Okay.
I believe that's how it's written.
Yeah.
So it would be opposing it, I guess. All these are, boy.
I read it, I thought it was a good idea.
That's
We'll
okay.
reread it and we'll see.
That's okay.
Because I read it quickly.
I read it quickly, yeah.
All right, so we'll hold off on that for now, and we'll reread that.
Well, it's gotta be, the letter needs to be sent before the end of the month, I think.
Right, so
We
we
do
can
have-
read it and just, I'll put it on for
Hearing
next
next
week's
week, right?
Yeah,
agenda.
we have a hearing on the 19th, so
It's just- yeah,
we can
for the
review
folks
it.
at Walmart.
If all the board members would read that, and you can discuss it at next week's
Sure.
agenda?
Any other future agenda items, anyone?
Oh, yeah. Excuse me, I need this for future meetings, pending a submission. I'd like the board to look at an added date of September 13th to add to the scheduled hearing,
What? I spaced out, what was it?
September 13th,
September 13th.
Yeah,
I
it's
know-
so far out,
after Labor Day.
I have no
I
idea.
realize that, but I'm asking you,
Oh,
because
yeah.
it'll be a very important.
Yeah.
Right now, I know I can't make that meeting, Sari.
I'm sorry?
I cannot make that date. Oh, I don't, I've made so many dates. My record's pretty good.
I don't care.
My brother's
No
getting
respect.
married that Friday, and it's the rehearsal dinner.
All right, all right.
We can go to the rehearsal dinner.
Of course you can. Come on down. I'll let you
Okay,
know where it's at.
I'll think about it. I mean, we'll see what we can do. If all the other board members, please get back to me with that date.
Yeah,
Do you
they
have
can
the
be there.
hearing date for the
I can
joint
go, let's
meeting?
pull
It's
it.
too late for the conference table.
I'm sorry?
The hearing date for the joint meeting, is
Yeah.
that on here?
I mean,
With the planning
yeah.
board?
It's July 31st.
But it's not on here.
I'll put it on. I
Yeah,
haven't
just to
got
let
it.
everybody know.
They just confirmed it. I did let everybody know in an email,
It's
and
open
we're
till
trying to
midnight.
figure out a time. So
Oh,
when we
okay.
get
All
the
right. Now I
time and
understand.
everything's set.
Okay.
I haven't responded to
Yeah.
that
I
yet.
should go.
Okay, thank you.
I'll go to Barton.
Seeing no further business, I think we are adjourned.